Next item number 43, let's say. In this case, I have filed IA, let's say, and that has not come. So let's say requisition is required, let's say.
Okay, call the IA.
May I please lordships? On my lord, MSc appeal, I am for the respondent claim and my lord. Matter was fixed for my lord admission, my lord. For listing, my lord. Matter has already been, my lord, issued date, my lord.
Settle.
Yes, my lord.
When do you want?
Okay, any date, my lord.
Next week,
Next week, my lord.
5th of June.
My lord.
My lord, there is an
And
IA.
And another matter, my lord, they say, my lord, hearing matter, my lord, may be posted for order, my lord. Hearing matter, my lord, your lordships.
5th of June.
My lord, obliged.
My lord, there is an IA 653 of 26. This court was directed to issue notice to against the opposite parties. My lord, by saying the order, there is a or case number is different and there is contents of the order is different. So it can be therefore we are unable to take the step.
Which matter?
IA number 653 of 26. This is a relay content petition. So can it be taken up on 28?
Oh, okay, 28.
So, my lord, there is another two MSc appeal and one MFA, which was last listed on 2024. And date was also fixed, but on the day it was not listed.
For what purpose?
For hearing, final hearing.
No, final hearing, it will not come. It will be maybe listed in orders column. Oh, orders column. 8th of June.
Please, your lordship. Lordship, I beg to mention item number 14. Lordship, we have filed an additional affidavit. The same may be called for.
Call the additional affidavit.
Obliged.
Yes.
Beg to mention item number 58, lordship. Today morning I filed the additional affidavit that may be called for.
Call the additional affidavit.
Your lordship, I beg to mention item number 63. Your lordship directed me to take steps. I could not take the steps. Let me just allow me to take steps within 1 week. Lordship.
Right, item number 60.
63 of the supplementary text.
Heard Mr. P.N. Goswami.
R for our lord.
Sorry. Heard Mr. R. Boralan, Standing Counsel, APDCL, who prays for some more time for taking steps for issuance of notice upon the respondents, as was directed by this court in its earlier order. The prayer is allowed. 15 days time is how much time?
To 1 week time.
1 week time is granted to take steps for issuance of notice returnable on 26 June.
So I am to mention regarding listing of two MAC appeal, one of 2018 and one of 2025.
Which
For
one?
orders, lordship.
Orders, 15th of June.
May I please, your lordship? It's by beg to mention item number 2, lordship.
2.
Yes, lordship. Kindly also note for the day, lordship. Solely engaged counsel S.A. Khan out of station, lordship.
Heard Mr. What is your name?
S.A. Mandal.
S.M.
S.A. Mandal.
S.A. Mandal, learned counsel for the appellant who prays for an adjournment on the ground of the personal difficulty of the conducting counsel for the appellant. Prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
My lord, this is a bail application matter, and that your lordship has disposed of my. So my.
No mentioning for bail application. You have to pray before registry.
Lordship, I beg to mention item number 50. The engaged counsel has some personal difficulty today.
Item number
50.
50.
Yes, sir.
Heard Mr. A. Mishra,
Mr. Ela.
appearing on behalf of Mr.
Ela.
A. Lal. You have informed the other side
Yes, lordship. Consent has been.
who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent appellant. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged.
Delegating PA, item 13. Item number 13.
Yes, something.
Item 14.
My lord, kindly pass over the matter for time.
After something. Or we'll take it up. Two matters are there only, criminal matters. At two. Or after some time, after some time.
Admission, item 1.
Wait, is your loss. This is an appeal matter against my lord grant of injunction matter, whereby my lord the
Grant of injunction.
injunction matter, whereby my lord the alienation of the joint family property as well as my lord construction of a building over the joint family property was restrained. Now, my lord, we have no grievance against the my lord alienation part because ultimately it's an ancestral property, my lord, but only our concern is with regard to my lord the restraint of the construction of the building, my lord. Had it been my lord, there was no construction, my lord, then it's a no issues, my lord. But since the construction has been stalled midway, my lord, we are facing tremendous loss, my lord, at this stage. So, my lord,
Okay.
just to summarize, my lord, I'm not going to go on the merits of this matter, my lord. Lords will kindly see. And
No.
just place the note, my lord.
Yes. Yes.
Yes, this is the family tree, my lord. This Nobin Chandra Chaudhary, my lord, he was the original Pattarana. And he died on 22 to 1986, leaving behind, my lord, two daughters, Kumudini, Promila, then two sons, Minal Kanti, Nihar Kanti, my lord. Now, the plaintiff was Nihar Kanti. He filed this suit for partition. He died on 11/3/2024, leaving behind the present legal heirs who have been substituted. We are the minor legal heirs of Minal Kanti, my lord, who are contesting this instant appeal, my lord. Sopola, Nilkamal, Santonu.
You are
also-
defending in this suit.
Yes.
Okay.
Now, the issue is this, my lord. Lords will kindly see the schedule, my lord. Nobin Chandra Chaudhary, my lord, left behind three properties which are described as Schedule A, Schedule B, and Schedule C. The only matter bone of contention is with regard to the Schedule A land. Here, my lord, this land, my lord, in Schedule A is covered by Patta number 239, and it has four ducts, my lord, 856, 857, 858, and 862. In the three ducts, my lord, 856, 57, 58, my lord, there is a total land of 1 bigha, 4 katha, 12 lessons, my lord. And this is a commercially viable land, my lord, having roadside connectivity. The other land, my lord, which is covered by duct number 862, my lord, is a bustling land, my lord, has no road connectivity. Now, this three ducts, my lord, 856, 57, 58, my lord, total land is 1 bigha, 4 katha, 12 lessons, my lord. And if we divide it by 4, my lord, since there are 4 legal heirs, my lord, it will be 2 katha, 8 lessons each. Now, out of the 2 katha, 8 lessons, my lord, the plaintiffs have admittedly sold 2 katha in duct number 856. So that means, my lord, they are only entitled to only 8 lessons in duct number 856, 857, and 858. But in their claim, my lord, they have also claimed an additional 1 katha 15 lessons in duct number 856, where they are presently, my lord, in possession with some shops also, my lord. And
That number?
856. 856. Now, this building, my lord, this building, my lord, is constructed over 1 katha 8 lessons, my lord, over duct number 857 and 858. So, my lord, now the lordship knows that in a, my lord, ancestral property, my lord, unless and until it is partition, its co-sharer or co-owner has equal rights over every parcel of the land until and unless the share is determined. Now, like,
Yes.
yes, issue is regarding this, my lord. I'm not going to submit on merit. Because of this injunction, my lord, the construction of the building has been stalled
Some construction is
Yes.
going on.
Ground level manner already constructed and the remaining floors manner are yet to be constructed, and because of this order manner the construction has been stalled and all the building materials are lying manner when we are facing tremendous loss day in and day out. Now manner the thing is this, what I am proposing is that we are ready to submit an undertaking before the trial court that the remaining construction be completed at our own risk and cost, because tomorrow, if it is found that this construction is not within our server, we are ready
No,
to.
is there any family arrangement
No,
amongst?
no,
Then how it is decided which share will come
that
in?
is why, madam, admittedly, if your lordship will kindly see, even if we
Now,
submit,
in whose possession the
we are,
land was?
we are in possession over the land madam, where the building has been constructed.
Okay.
And if.
And your case is that the plaintiff has already sold 2 kathas of his entitled share.
Yes,
Out of 2 kathas, 8 lechas.
yes.
Okay.
Yes, so since the thing is this, madam, tomorrow if it is found out that the building was constructed well within our share, there is nobody to compensate us for our loss. But we are, what we are proposing is that we are ready to give that undertaking that if it is found that the building is constructed in their share, we are going to demolish it at our own cost and our expenses, that we are ready to submit. Only that much. Because even if we go by the 3 principles, balance of convenience, we are facing loss. We are at an inconvenient position, because of this, they are not within the possession also. The land is in our possession.
So it is for partition.
Yes.
Partition
It's a joint family property.
entire,
Yes.
including schedule B land or
Yes.
B and C also.
Yes. Let the trial court decide on the shares, individual shares, which will be determined at the end of the trial. But at this stage, I don't think there should be any encumbrance upon how I am enjoying the land.
Yes, Mr. Jain.
I vehemently object this, your circumstance. First, it is admitted fact that it is a joint property. And second admitted fact is that there was no partition and no share was actually ascertained within the parties.
But somebody is in possession.
No, somebody, but one thing is there, if there is simple possession, then there was no objection. But they are constructing building. If the building is constructed and they sell out the shops and others.
No, selling part we will
No, no.
rest.
If they constructed the building, it will be very difficult to get the possession of the said land if that possession is come to my share. And it will create multiplicity of proceeding and complicated the whole procedure. Unless there is a settlement of the share and foremost, Your Honor, my lord, that the Honorable Trial Court has used its discretionary power to grant injunction. First interim injunction was granted, then after hearing the parties, the injunction was made actually. And in the injunction, the
Okay.
trial court decided
It
all
will
the
be
three-
contested. We'll admit the appeal and hear the matter on merit.
The appeal is already admitted.
Not admitted it for admission.
Then why it has come for admission? It is not yet admitted.
Let it be admitted, according to call for, and the entire matter may be heard to you.
The respondent have been substituted.
Yes.
I am for the substituted legal advice.
Service is complete.
Yes.
We'll fix a date for hearing.
Next.
Because proposal which you have made is not agreeable. Is there any hope of conciliation? This is amongst.
In my chamber, informally we have said, but they are saying that you take this land in the front land, but there is no passage. Unless there is passage, it will be no utilization for me.
No, work out the passage. You can sit and work out.
Yes.
instead of fighting amongst yourself.
We have probably waited the last 3 years, madam, for an amicable settlement.
When the urgency is there, the order was passed in 2023. Now it has come for admission. Two years, 3 years.
Because of my lord,
already passed.
substitution
Why?
issues, my lord, because my lord, the plaintiff, my lord, he died. So we had to substitute the legal heirs, my lord, send them.
Now, what has happened to the trial in the meanwhile?
Trial, my lord, has
Trial.
been in that stage only,
Why?
WS.
No.
We have filed WS, my lord,
No,
and probably issues have not.
I was there in the trial. I filed the petition for imprisonment of certain parties. They have sold out some certain portion of the land, so to make them party, and matter is pending to them.
Because the parties are related to each other.
Yes.
It would be good if some attempt is made. We are fixing a date for final hearing. We'll admit, in the meanwhile, you may try. Or we send it for formal mediation.
Formal mediation will do.
Well, I'll take instructions, sir. Boss will fix that too, my lord.
What it
Okay,
means,
okay.
final hearing, it can be.
No. We'll take it up at 2. Let him take instruction. If mediation is possible, let us give a try. At 2, we'll take it up.
Item 3,
itu yatte rakhe. Yes.
Should I have framed a substantial portion of law? It's an MFA matter.
Yes, what is the matter?
Should the service on respondent number 2 is not complete, but the matter has been listed for admission. Should the sole ground is that the employer-employee relationship was not established. The owner, he remained ex-party and he did not appear before the learned commissioner.
Heard Miss A. Biani, learned counsel for the appellant. Also heard Mr. What is her name?
Says Ahmed, 1 and 3.
S.S. Ahmed, appearing for respondent number 1 and 3. Who is 2? Owner of the vehicle. This appeal under section 30 of the Employees Compensation Act 1923 has been preferred by the appellant New India Assurance Company Limited, impugning the judgment and award dated 16/11/2022, passed by the learned Commissioner, Workman's Compensation, Dhubri, in WC case number 17/2006, whereby the present appellant was directed to pay a compensation amount of rupees 4,52,760 along with interest to the claimants, respondent. After going through the memo of appeal and after considering the submissions made by learned counsel for the appellant, following substantial question of law is formulated in this appeal, whether the judgment of the learned commissioner, which has been impugned in the instant appeal, is hit by perversity in holding that there is an employer-employee relationship between the deceased and the owner of the who is the owner? Owner of the offending vehicle. Within bracket respondent number 2. Stop. Issue notice to the respondents. Since Mr.
Says Ahmed.
Ahmed has appeared for respondent number
1 and 3.
1 and 3, no formal notice need to be issued to the said respondent.
It has been almost 3 times, the notices were issued to respondent number 2. It was left unserved. Let it be paper published. Most probably is the 3rd time.
Yes, Your Lordship, and the delay condemnation.
But there is no, this is for the first time it is coming. That is a different chapter. However, in respect of respondent number 2, the appellant shall take steps for issuance of notice by speed post as well as by usual mode. It is submitted by learned counsel for the appellant that in the connected interlocutory application which was filed by the appellant for condonation of delay or in filing the instant appeal, on several occasions notices were issued to respondent number 2 by speed post and usual mode. However, same could not be served. Hence, she submits that in addition to usual mode, the appellant may also be allowed to take steps for issuance of notice by substituted mode of publishing the notice in the newspaper.
Should we take steps by speed post and usual process first, and then if unserved, we'll take by substituted manner?
Take steps within 7 days, returnable on 17th of July.
That I for stay. Your Lordship, we are ready to deposit the entire amount together with the interest accrued till date. I 2984.
Let me say, Biani Learned Counsel for the applicant insurance company. Also, Mr. S.S. Ahmed.
Yeah, for 1 and 3.
Appearing, for claimant also you are appearing?
Claiming.
Appearing for respondent number 1 and 3. This interlocutory application has been filed by the applicant insurance company in connection with the miscellaneous first appeal number 38/2025, praying for stay of execution of the judgment award dated 16/11/2022 passed by the Commissioner Workman's Compensation Authority in WC case number 70/2006. Learned counsel for the applicant submits that applicant insurance company is ready to deposit the awarded amount as a condition for grant of stay of the impugned judgment and award. Considering the submissions made by learned counsel for the applicant, notice to respondent number 2 is hereby waived, and this interlocutory application is allowed. The execution of impugned judgment and award dated 16/11/2022 passed in WC case number 70/2006 shall remain stayed during the pendency of the connected miscellaneous first appeal subject to deposit of the awarded amount by the applicant insurance company before the registry of this court within a period of 4 weeks from the date of this order, list accordingly.
Item 4.
Eight, please, your honor.
This IA is disposed of. Yes,
Eight, please, your lord. Can this matter be kindly be taken after some time, your lordship?
okay.
Highly.
Yes, sir. For respondent number 3. Allowed your lordship a copy may be given.
You give the copy. We'll take it after some time. In the meanwhile, you may furnish the copy.
Item 5.
Wait, please, Mr. Lawson. Well, this is an appeal matter under section 96 of CPC. Against the judgment and decree dated 14/11/2025, passed by the Ghana Civil Judge Senior Division.
What was the judgment?
Judgment, my lord, appellant as a plaintiff, my lord, file a money suit for recovery of, my lord,
Court was dismissed or allowed?
dismissed.
Dismissed. Heard Mr. H.P. Gwala,
My lord.
learned counsel for the appellant. Also heard Mr.
B does.
B. Das, learned
Order.
standing counsel APDCL, appearing for all the respondents. This appeal under section 96 of the Code of Civil Procedure 1908 has been referred by the appellant Prahlad Kumar Das, impugning the judgment and decree dated 14/11/2025, passed by the Court of Learned Civil Judge Senior Division, Nagaon, in money suit number 22/2022, whereby the money suit filed by the present appellant was dismissed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Since Mr. Das has appeared for all the respondents, no formal notice need to be issued. However, you have received the memo of appeal. Stop. Let the records of money suit number 2022/2022 be called for from the trial court, the registry to take steps for requisitioning the records. Let this matter be listed again on 22nd of July. Hmm? The appellant is directed to furnish requisite number of extra copies of the memo of appeal as well as annexures to the learned standing counsel APDCL within a period of 7 days from the date of this order.
Item 6.
Yes,
Your Lordship, I filed a title suit for specific purpose of contract for compensation, for permanent injunction, etc. in relating to a memorandum of understanding agreement as arrived with the respondent side. So I have sought for this relief before the trial court, Deputy Trial Court, Your Lordship. And accordingly, the respondent side appeared, but they did not file, instead of filing written statement challenging our claim, rather they filed a application for rejection of my claim,
your plaint was rejected.
for rejection, and my claim was rejected. Two grounds,
Against
because,
that rejection order, you have filed this appeal.
yes, Your Lordship,
Oh.
yes.
What is your case?
Can I start?
Yes.
What has happened, there's agreement between the plaintiff, appellant and the respondent number 3 and 4. Respondent 3 and 4 is a state corporation and 4 is the managing director. After that, they have failed to pay the rent and the share for 7 years. And after a meeting on the decided that their agreement was cancelled as per clause 15 and 20 of the agreement. Thereafter, they filed a petition before the Honorable High Court. The Honorable High Court has first not interfered with their petition. They have challenged is notice of cancellation and others. In the Honorable High Court has said that what the corporation has done is as per law, and but as there is no in the notice, there is no any clause for eviction of the how the procedures will be made. So he should be evicted from the corporation with due process of law. Therefore, as per section 4 of the Assam Public Premises Act, asset officer was appointed by the governor of Assam. Thereafter, notice was issued to them. Thereafter, they filed a suit for selling the same thing and
Challenging the notice.
and not to evict from the supermises. As per section 15 of the Assam Public Premises Act, the food is barred of the Assam Public Premises Act.
And therefore, it was rejected. Where is the impugn order? Impugn order.
Your lordship,
Where is the impugn order? Which page?
a long order, your lordship, from
Yes, which is the page number?
page number 1 to
1.
sorry, here. In-person. Page number 15 to 41. 15 to 41, your lordship.
On what ground the plaint was rejected?
Just I am reading out, kindly look.
No, you don't read. Just tell me on what ground your plaint was.
It was rejected on 2 counts, your lordship. One count is, since it is barred under the Public Premises Act, number 1. And second second cause is that it is under res judicata, 2 grounds. So your lordship, what I am submitting before your lordship, I am not challenging the that eviction. I have not, and one thing, another proceeding is drawn up by the state officer, the Deputy Commissioner Karbi Anglam. And we have also appeared and we have submitted our written objection denying the all allegations made in the that eviction proceeding, ejectment proceeding. Because your lordship, I have an agreement with the respondent side. They entered into an memorandum of understanding. Kindly look into your lordship page.
No, impugn order starts at page 15.
Yes.
15 to
15 to 41.
41.
41, your lordship, and operative part is, main operative part is at clause 9 of the impugn order, your lordship. Page 40.
What is 15A of Assam Public?
Yes, it is.
May I read?
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of eviction of any person who is in unauthorized occupation of any public premises or the recovery of arrears of rent payable under so and so, or the damages payable under the section so and so, or costs awarded to the government of Assam under section so and so, or any person of such rent damages or costs. The proceedings under SLF is going on.
What is your ground of appeal?
My ground, I am not unauthorized occupant. Because your lordship, they invited me to start a public-private partnership project, joint venture. Kindly look into my MOU. I have annexed here with MOU. Your lordship, MOU is start as page number 1.
No, you show me the grounds. I have to take a decision whether to admit it or not. If there are grounds for admission, we'll admit it and then thereafter we'll hear it.
Number one ground as shown in the impugning order that it is res judicata. But it is a settled principle of law. Recently, I have some authority of law.
Yes, that.
Claim cannot be rejected on the ground of res judicata. It is one of ground. So I have assigned on this ground. And I have a citation also, Supreme Court.
And on the bar by statute.
Statute, I have not challenged the eviction proceeding. Number one, your lordship. And I have already invested a lot of amount in the business. And I am a partner to that project. I'm neither tenant, I am in land use, not I am unauthorized occupant. They permitted me to start the project, your lordship. And this is my your lordship, kindly go to the prayer of my plaint. I have annexed my plaint also.
Okay, we'll admit the appeal.
Yes.
Admit the appeal, then heard Mr. What is your name? Heard Mr. Yudas, learned counsel for the appellant. Also heard Mr. S.R. Gogoi, learned counsel appearing for whom you are appearing?
That's one number 3 and 4.
Appearing for the caveator / as well as respondent number 3 and 4. Who is appearing for 1 and 2? 2. You are appearing for 1 also, State of Assam. Deputy Commissioner Difu, who is appearing? Also Mr. T.R. Gogoi, learned government counsel, appearing for respondent number 1 and 2. Mr. Gogoi, you are appearing for 3 and 4.
Yes.
Okay. And 5?
Private parties, I.
Okay, we'll issue notice. This appeal in the section 96 of the Code of Civil Procedure 1908 has been preferred by the appellant Shri Ashok Gupta, impugning the order dated 2/4/2026 passed by the Court of London Civil Judge Senior Division Karbi Anglong Difu in Miss J case number 8/2025 in connection with title suit number 3/2005, whereby the plaint filed by the present appellant in the aforesaid suit was rejected. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for both sides. This appeal is admitted. Let the records of the title suit number 3/2025 along with that of Miss J case number 8/2025 be called for from the trial court. Let also notice be issued to the respondents. Since Mr. T.R. Gogoi has already appeared for respondent number 1 and 2, as well as Mr. S.R. Gogoi has appeared for respondent number 3 and 4. No formal notice need to be issued to the said respondents. However, the appellant shall furnish requisite number of copies of memo of appeal along with annexures to the learned counsel for the aforesaid respondents. As regards the other respondents are concerned, the appellant shall take steps for issuance of notice to them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 17th of July, list accordingly.
Your lordship, I have an IA also
I will issue notice. What relief you are seeking?
for stay of the enforceability of that impugned order. Because today I don't.
Impugn order, if we stayed, how rejection order will be stayed?
Okay.
What matter it? I may be dismissed or you withdraw it. We will not pass any order on I.
Because
Yes, there is nothing to stay.
the plane does not exist. It's a husband of the Honorable Supreme Court and the Gujarat High Court.
No, in rejection,
Yes, okay.
stay is not maintainable. You may withdraw it.
Yes, I will. Your lordship.
The stay application. Mr. Yudas, learned counsel for the applicant, praise for allowing the applicant to withdraw this interlocutory application. There is allowed. This interlocutory application is dismissed or withdrawn.
How like?
Item 7.
May I please your lordship? Your lordship, the present appeal has been filed under section 23 of the Railway Claim Tribunal.
20.
3.
Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Mr. M.R. Adhikari, learned Central Government Council. Central Government Council appearing for the sole respondent. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant. Where is the memo? By the appellant, impugning the judgment. Your claim case was dismissed.
Yes, my lord.
Impugning the judgment and order dated 19/2/2026 passed by the Railway Claims Tribunal, Gauhati Bench in OA number 1/1-07/2018, dismissing the claim of the present appellant. I have gone through the grounds stated in the memo of appeal. The appeal is admitted. Let the records of the original application be called for from the Railway Claims Tribunal, Gauhati. Registry to take steps for requisition of the record. You have received the copy. And the appellant is directed to furnish requisite numbers of extra copies of the memo of appeal as along with annexures to the learned Central Government Council appearing for the respondents. Let this matter be listed 20 July.
Grateful, my lord. My lord, for item 8 and 9 as well, my lord.
8 and 9 same order.
Same order.
You are appearing in 8 and 9 also. 8 and 9 same order. Case number will be different. Instead of name of Mr. Adhikari, who is appearing? Yes, his name may be same order.
Grateful, my lord.
Item 10.
His appeal, appellant has filed his appeal, challenging the quantum.
Heard Mr. N. K. Kalita, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been filed by the appellant Nandeshwar Deori, impugning the judgment and award dated 14/6/2014 passed by the 2014 award 2024 passed by the Motor Accident Claims Tribunal number 3 Kamrup Metro in MAC case number 1570/2018. The appellant is basically aggrieved with the quantum of compensation awarded to him. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 1570/2018 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July.
Public. Item 11.
Wait, please, your lordship. But we have filed the appeal for enhancement fee.
Quantum,
What?
heard Mr. S. Burning, learned senior and counsel assisted by Ms. Fiza Begum, learned counsel for the appellant. This appeal under section 173, just like previous order, you take steps within 7 days, returnable on 22nd July.
May I pray it would be on convenient 24th of July, because the other appeal 248 of 26.
24.
Mother and son.
24th July.
And
Let the records of MAC appeal number
248,
248 be tagged
2026.
of 2026 be tagged with the present appeal on the next date fixed.
Item 12. Item number 12.
Issue notice. Issue notice. Same day. 24th July.
Filing item 13.
Yes.
In this case, a petitioner has surrendered before the learned court in connection with this case on 11th of November. And since then, thereafter, he was taken to police custody for interrogation for 4 days. And after completion of police custody, he has been remanded to judicial custody. So, my lord, my humble submission is that while taking into judicial custody or sending into judicial custody, police has
Since when you are behind bars?
since 11th of November 25.
2025.
Right. But the case was registered on 6th March 25. After 8 months of registration of the
What is your ground?
ground is that, my lord, some codeine, let me kindly turn to FIR. At page 17, last paragraph, 17.
This is your first bail application.
My lord, no, that was earlier rejected by the learned lower court below. FIR, no, once in page 17, my lord, your lordship will find the FIR of party portion. May I read out? Later, all the recovered Bonkov C syrup which are containing codeine phosphate were count together and found total 240 numbers of 100 ml bottles of Bonkov C contains and G codeine phosphate is in each 5 ml syrup batch number so and so of 196 numbers and LPS so and so. Accordingly, seize the cough syrup along with Maruti Suzuki vehicle and the scooty bearing number so and so one laptop as used from the house of Boga, alias Nazir Kazi, as per seizure list in presence of available witnesses, observing all the formalities under the LPS. So, my lord, on that particular time, on 6th of March, when this contrabands of codeine phosphate syrup was seized by the police, I was not at my home. And some other person was allowed to stay at my home. So I was totally not aware about any offense committed by some other person in this manner. So after 8 months, when police tried to
Now, what is the stage? Charge sheet has been submitted.
Charge has also been framed, Lordship,
Charge has been framed.
framed on 5/2/2026. Moreover, my learned friend, just now, I want to go to page number 17, Lordship. And just be in the first, second, fourth para, Lordship. May I read, Lordship?
Yes,
He-
no, just.
It is clearly stated that he he ran away, Lordship. But one adult male ran away from the house on seeing police party and vehicle. The male adult who is run away from the house later identified as the present petitioner, Lordship. He stated that he is not present.
Okay, let him complete his submission.
Lordship.
Yes.
Why not on if I before patrolling party or any police party, a person can escape from the place of occurrence matter. Is it possible in the day or and in front of many villages?
Everything is possible.
That is authorized by law.
Now, is there any other ground?
Yes, madam.
Section 37 is there.
Because there are section 37. we know.
How will you overcome section 37?
And, trial may be prosecuted because no witnesses has been examined till date. And so far as arrest, with regard to grounds of arrest, if you lordship would peruse in the TCR, lordship will find that whenever I have my arrest has been justified by police, then police is bound and duty to make the grounds of arrest in respect of the accused person. That has may not been done.
Will show me.
Lordship may done TCR, madam. That copy is not with us.
So, no, on what ground you are seeking bail?
I'm seeking bail because I am nowhere connected.
You
with the
have to
offense.
show, is it your submission that grounds of arrest were not communicated to you?
Yes. That is also a part of.
Whether 47 notice is there?
Moreover, he has not also raised in the petition, Lordship.
I have stated my.
I have not looked into that.
Ramesh, record to PP Gyok. Go through 48 notice.
Where I have stated.
CD is not there, but only some few items are there. Documents are there.
Then we'll call for the case. Sir.
Need the order sheets are there.
Stop. Heard Mr. R.
Apple.
A. Paul, learned counsel for the appellant. Learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. After going through the contentions raised by the petitioner in the instant bail application, perusal of the scanned copy of the trial court records, as well as scanned copy of the case diary of the which PS case number?
Bhattacharya PS case number 61 of.
Bhattacharya PS case number 61/2025 would be required. Hence, let the same be requisitioned. Registry to take steps for requisitioning the scanned copy of the NDPS case number 30/2025, as well as the scanned copy of the above mentioned case diary. Let this matter be listed
The trial court.
from the trial court. Let this matter be listed again.
15 too long. First week of the. For month. You can look for. Look, after me, to-
3rd June.
oh,
Item number 53. Supplementary item number 53.
Your Lordship, a new learned counsel will appear in this case. 3 weeks times may be given to you.
Lordship may kindly peruse, order dated 16/11/2022, Lordship, in IA number 508 of 2020, Lordship. The delay was condoned subject to payment of rupees 7,000, Lordship.
Whether that payment has been made or not.
As per my knowledge, Lordship, no payment has been made, Lordship.
I saw. I Ramesh Putul, anybody, I. Which I?
IA number 508, Lordship. 508/2022 or 20, Lordship.
The order is not very detailed order. You have not paid costs.
Counsel who was engaged in this.
We will not admit the appeal. We'll give one more chance. Heard. Miss, what is your name? L. Thakur.
L. Thakur.
What is your name?
Lakshmi Thakur.
Miss L. Thakur, appearing on behalf of Mr. S. Sahu, learned counsel for the appellant, who seeks 2 weeks' time, who seeks an accommodation for 2 weeks on the ground that a new set of counsel would be appearing for the appellant in this case. On the other hand, Mr.
S.A. Singh, Lordship, on behalf of IKBR, Lordship.
S.A. Singh, learned counsel for the respondent, has submitted that in the instant case, the instant appeal has been filed after a delay of 624 days, which was condoned by a coordinate bench of this court in the connected IA civil number 508/2020. He submits that while condoning the delay by its order dated 16/11/2022, this court had imposed a cost of rupees 7,000 upon the present appellant. However, the said cost has not yet been deposited by the appellant. He submits that this appeal should not be admitted unless the appellant pays the cost as was directed by this court. Stop. 2 weeks' time is granted to the appellant to comply with the order dated 16/11/2022. Let this matter be listed after.
Short date may be given. Because the execution, title execution has been stayed
Where?
in Kamrup Metro, Lordship.
Who has stayed it?
Right. There is another order dated
Yeah.
Yes, 15/2/2022, passed
We-
in the same IA lordship,
Yes.
508/2020.
We'll vacate this stay. If
By that order, the execution has been stayed, lordship.
15,
Order dated 15/2/2022, passed in IA number 508/2020.
it appears that they paid 7,000 or not. They have not yet paid. Then we are vacating this stay.
Lordship, 2 weeks time.
I am giving time to you, but stay will not remain further. You have not complied with the court's order. You inform this court after some time whether that cost has been paid or not. Amendment के क्या लिखा last line क्या लिखा है? No, stop. एक paragraph और add करो. It appears that by order dated 15/2/2022, passed in IA civil number 508/2020, the execution proceeding in title execution case number 30/2018 was stayed by a coordinate bench of this court. However, it appears that there is nothing on record to indicate that the present appellant has complied with the direction of this court which was passed on 16/11/2022, whereby the appellant was directed to pay a cost of rupees 7,000. Accordingly, since the appellant has not complied with the direction of this court, the interim stay on execution of the stay of the execution proceeding of in title execution case number 30/2018 is hereby vacated. You take in instruction. If you can inform this court that you have deposited, we will delete the last paragraph. Otherwise, it will remain.
So the memo maybe is because it has not been charged upon us.
We have not yet admitted the appeal. Suppose within 2 weeks, they fail to comply with that order. Appeal will be dismissed after 2 weeks.
Timing item 4. Item 4. Orders item 15.
Yes.
Your notes. We have deposited 50% amount.
Third, Miss, what is your name?
P,
P. Sahu. No, no.
P Sarma, sir.
Sorry. P. Sharma, learned counsel for the appellant. None has appeared for the respondents. It appears from office note dated 19/5/2026 that the records of the MSC case number MEC case number 1297/2008 have not yet been received from the concerned tribunal. Issue reminder for the same. List this matter again after receipt of the records on. I say. Yeah, लिखिस. ये कौन On perusal of the records, it appears that the records of the concerned MEC case have been received. This appeal is therefore ready for hearing. Let this matter be listed for hearing 3rd of September.
Item 16.
My lord, Respondent 1 and 2 appeared, my lord. 3, my lord, we have already taken justice service, we have to file affidavit in this regard. And Respondent number 4 expired, my lord. So we have to substitute the legal.
Heard Ms. L. Sharma, learned counsel for the applicant. Also heard Ms. R. Gogoi, learned counsel appearing for respondent number 1. Learned counsel for the appellant submits that the appellant has taken steps for issuance of notice upon the respondent number 3 by way of dusty mode. However, she prays for some more time for filing an affidavit in compliance thereto. She also submits that since that it has come to the notice of the appellant that respondent number 4 has expired, and therefore she prays for some time for taking necessary steps for substituting the legal heirs of the deceased respondent number 4. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed. After 4 weeks on a date to be fixed by the list.
Item 17 and 18. In item number 18, I appear on behalf of Mr. T. Kolita, having some difficulty today.
In 17,
In 17, I had no instruction to appear. In 18, my lord, service is complete, DCR also received. Part of this note, class officer.
17, who is appearing?
I don't, 17, I'm on behalf of the petitioner, my lord. My lord, on the last date, this court was directed to rectify the order dated, my lord, 4/6/2025. However, my lord, 17/3/2025, the opposite respondent 1 was appeared. So it is not necessary to serve notice, because an earlier days that advocate for the respondent number was also T. Kolita, my lord. Order dated 17/3/2025.
What is this I for?
My lord, delay condonation petition.
Condonation.
Yes.
You can appear on behalf.
Fine.
Are you objecting?
No.
You have instructions from Mr. Kolita
Yes.
not to object.
No, I do not have, but since it's a delay condonation, that may be. Otherwise, my lordship may fix it some other day, let him come. It is not proper for me to.
Delay condonation for filing the
MSC appeal, my lord. It is cross appeal, my lord. Item number 17, 18 is the same arising out of one incident and for one judgment. So I am filing the MSC appeal for enhancement. And they are challenging the judgment of the trial court in item number 18, my lord.
Okay, then let us condone the delay.
Yes.
Earlier, my lord, they had also the delay. I have Even no objection if they are
Their delay was also condoned.
condoned. I have given no objection.
Okay, heard Mr. B. R. Das, learned counsel for the applicant in 17. Also heard Mr. A. Bhattacharya, appearing on behalf of Mr. T. Kolita, learned counsel for the respondent insurance company. This interlocutory application under Section 5 of the Limitation Act has been filed by the appellant / claimant for condonation of delay of 121 days in filing the connected MAC appeal, whereby the judgment and award dated 8/10/2021 passed by the Motor Accident Claims Tribunal Dhemaji in MEC case number 25/2018 has been impugned. The applicant has been impugned. Stop. Considering the grounds, stop. Learned counsel for the applicant has where are the grounds? Has submitted that
5, 6, 9, 10, 11.
the applicant has stated the grounds for delay in preferring the connected appeal in paragraph number 4 to 7,
14.
4 to 14 of this instant interlocutory application. Stop. Considering the grounds stated in the application, learned counsel for the respondent insurance company does not oppose the said prayer. After considering the said ground, after considering the ground stated by the applicant in the instant interlocutory application, this court is of considered opinion that the cause shown by the applicant may be regarded as sufficient cause which has prevented him from preferring the connected appeal within the prescribed period of limitation. Accordingly, the delay of 121 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected appeal and list the same for admission after 2 weeks on a date to be fixed by registry. 18.
Item 18, my lord, service complete, TCR received.
Shall received. Heard Mr. A. Bhattacharya appearing on behalf of Mr. T. Kolita, learned counsel for the appellant insurance company. Also heard Mr. B. R. Das, learned counsel for respondent number
Only one.
1. Slash
Received.
1/claimant. This appeal is ready for hearing. Let this appeal be listed for hearing after 4 weeks on a date to be fixed by registry.
Right, take. Item 19.
May I please, Your Lordship? We have taken steps on all the respondents. They are yet to appear. But on the last order, Micus was appointed. We have also served an extra copy to them.
Who was
I do that.
record? Heard Miss P. Heard Miss P. Fukon, appearing on behalf of Mr. P. J. Burman, learned counsel for the appellant. It appears that on last date, that is on 4/5/2026, Miss R. D. Majumdar was appointed as amicus curiae to defend the cause of respondent number 1 and 2 in this appeal. However, it appears that her name has not been reflected in the cause list today, and perhaps therefore she is not present before the court. The registry is directed to reflect the name of Ms. R. D. Majumdar as amicus curiae for respondent number 1 and 2 in the cause list henceforth. Let this matter be listed 2 weeks, 24th of June. You have paid the cost. Okay, last parato, kati dibo. On next day, you give some proof of payment of costs after 2 weeks.
Item 20.
Stay vacate kora jitu order asile etu remi.
Last order, we were directed to take steps from respondent number 2. But we could not comply with the order due to some miscommunication.
Heard Mr. S. Sharma, learned counsel for the appellant. Also heard Miss B. Hajorika, appearing for respondent number 1, as well as Mr. S. Sutradhar, appearing for respondent number 3, 4, and 5. Learned counsel for the appellant submits that due to some difficulty, the appellant could not comply with the direction of this court for taking fresh steps for issuance of notice upon respondent number 2. He prays for some more time for comply with the said direction. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July. 22nd July.
Item 21.
Where to your office? Well, this is regular first appeal against decree passed in suit for specific purpose of contract, where the decree for specific purpose of contract was actually not passed. Decree was passed only to refund the advance amount that was paid.
Okay.
As against that, we preferred the appeal. The appeal was filed in 2024, and in December 2024, the notice was issued on the application for condonation of delay.
Appeal there is a delay.
246 days. And the respondent has not filed the reply to the application for condonation of delay in the entire 25 whole year. Now we are in the half of 2026. In the meantime, what has happened, my lord? They have filed, they are pursuing with their execution case. They are not appearing here.
No, what execution? The
Execution, they have filed
depositing of the money.
No, yes, for recovery of the amount. Since we have not paid. Now, my lord, our intention is to pay the money. We want to sell the house which we wanted to sell him, my lord. But he is not allowing us to sell the property because he wants to ensure that if it is sold in auction, my lord, he can manage things because I have filed a specific affidavit, my lord.
But the decree was only to repay back the advance.
Yes, my lord. Now they have attached the property and there is a date fixed for auction sale, etc. Because they want to ensure that if the entire land and the building is sold in auction.
How much money?
56 lakhs. And whole land and building itself will cost my lord 1 crore. That is the, my lord, apprehension of the present appellant before your lordship, for which we have filed an additional affidavit stating all these facts, how he is debarring us from selling the property so that we can pay the decretal amount to him. Now there is an attachment, now it will be sold, and now today they are asking for time after 1.5 years for filing objection or reply to the application for punishment delay. So that in the meantime, my lord, the house is sold.
Otherwise also you are going to sell the house.
I want to sell, if I sell, madam, I'll be selling at a market price. This is the only problem, madam. We will sell it at the market value, but they want to ensure that if it is sold in execution, madam, it is
Now it has been attached.
attached. And today they are asking for some time, so that in the meantime, everything happens.
Yes.
My lord, my senior colleague is on delay condonation petition.
Yes.
I have not even made my prayer for filing objection to the delay condonation. My submission at this stage is, I am in receipt of a copy of an additional affidavit filed by the appellant in the delay condonation petition, wherein a prayer has been made to allow them to sell the decretal property, not the decretal, the attached property, so that it can fetch a proper market value, and they would deposit this amount before this honorable court to satisfy the decretal amount. And my lord, to correct my senior colleague, it is not a suit for specific performance of contract, it's a money suit. And the money execution case is pending. So, your lordship, in execution of the money decree, the property belonging to the judgment debtor was attached. Money execution was filed. After the filing of the money execution case, they came up in appeal, and that's why this inordinate delay of 246 days in preferring the appeal also. There is laches in regard to that also. But for a while, my lord, this additional affidavit, in my humble contention, a prayer cannot be made in an affidavit. If there has to be any prayer of this sort, it has to be by way of an IA. In my respectful submission, in my humble understanding of law, my lord, they are making a prayer before this honorable court to allow them to sell the attached property so that it fetches proper market value. And this is a prayer that they have also been making before.
This prayer you can make before the executing court.
Absolutely, I have not made such prayer. It's only an additional affidavit. My learned friend is not correct in saying that I am making. I'll make the prayer before the appropriate court at the appropriate time. I have only filed this additional affidavit to bring to the notice of this court the conduct of the decree holder. Why he is interrupting me from selling the property to a person of my desire? Those
But these issues can be agitated before the
Absolutely.
execution.
My lord,
Here we are concerned only about delay.
delay, and my lord, once the delay is condoned, that's what I'm saying. Once the delay is condoned, the appeal is, my lord, hard on merit. We have, by the averments made in this additional affidavit, we are saying that we want to pay the amount. Kindly do not come in the way of my intention to sell the property so that I can pay the amount. Whether you are interested in the decretal amount or you are interested in ensuring that my property is sold at a much lesser value than the actual value of the property. This is the only concern, my lord, and that is why he is suffering. Nothing else.
My lord,
He should be, the decree holder should be interested only to get the decretal amount.
Okay, what should we do with this?
This additional affidavit is concerned, I pray for a reply, because why I pray for a reply?
No.
No, if it is.
Let it be there on record,
Yes.
because that will deviate this court from its course. Where we have to consider the delay condonation application.
Is concerned, I have my objections. If it is to be made verbally, that also can be made. If your lordship allows me to file a written objection to that, that also will suffice me. Because there is an inordinate delay of 246 days in filing this appeal.
No, it is coming for the second time only.
Yes, after my appearance, this is coming for the first time. After me entering appearance, this is come for the first time.
You are appearing today for the first time
Yes,
No, no.
for the sole respondent
in the IA.
in the IA.
He has appeared today only.
That's what I'm saying.
What is
They
your-
are aware that the first appeal is filed. They are pursuing their execution case before the executing court, but they are not appearing here deliberately and watching the proceedings of the case from the fence, so that at the appropriate time they come and they further delay the matter by asking for time to file everything.
No,
Well,
no,
I
but,
don't understand, that's
but you took steps for issuance of notice only on 20 May 2026.
No, no, before that also it was taken, madam. They are avoiding.
But this does not reflect, the office note does not reflect.
My lord, yesterday's development.
No, what do you want? You want to file objection?
Objection
When?
in the delay condonation.
When?
Lordship gives me 2 weeks time. My lord also gives me some time to, this same time, this 2 weeks time, also to
Well,
file a reply to this.
Well, we are in May, we have made a specific statement that they entered appearance on 9th of January 2025
Where? In which?
in the additional affidavit.
In which case?
In the IA, my lord.
No, order sheet does not show.
No, my lord, in the IA, I have made a statement, that's what I'm saying.
Statement is on what basis?
In the online,
No, this ROK record আছে.
My lord, my.
Huh? This I is coming for the second time before this court today. On the first occasion, that is on 29/12/2025, direction for issuance of notice was made. And thereafter, you took steps on 18/12/2024.
And my lord, this allegation is now coming from my senior friend that
No,
I am
no, no,
avoiding.
please don't
My lord,
interrupt.
I am not about him, my lord. I am about his party, man. Not making any statement against the lawyer.
We will give 1 week time to them for filing out.
My lord, objection in the delay condonation petition and your lordship allows me to file reply in this
There's no
affidavit.
question, he can always file, my lord. Let him file, there is no difficulty. Let him refute the allegations which I have made.
Because there are serious allegations in this affidavit.
Lordship will fix a date. my
We will not decide that question.
My lord,
Heard Mr. D. Majumdar, Learned Senior Counsel, assisted by Mr. G. R. Datto, Learned Counsel for the applicant. Also Mr. B. Chakravarti, Learned Counsel for the sole respondent, who prays for some time for filing written objection against the prayer for condonation of delay. The prayer is allowed. Let this matter be listed after a week.
29.
no, 29.
Date at the
24.
of
After 1
24th
week.
of,
after 1 week, first week of the
my lord, can it be on 8th of June? I'll not be there on the first week of June.
8th of June.
8th of June. Oblige.
Item 22 and 23.
In this case, my lord, the service is complete.
I
I am for the claimant lordship. It is a death case lordship. I have preferred appeal and for the insurance company, a cross appeal has been filed. And there are two IAs in the cross appeal filed by them. One for delay lordship, delay is 64, I have no objection lordship. And another IA for stay. So lordship, both the IAs can be allowed and the entire.
No.
both the eyes cannot be allowed.
Appeal has
First,
been
delay
approved.
has to be
Yes, yes.
condoned, appeal has to be registered,
Yes.
and we'll direct listing next week, then that I will be taken.
And the statutory amount deposited them by them may be disbursed.
No,
Husband has died. Lord.
while how much compensation has been paid?
25 lakh.
If that we will consider while taking up their stay application. Heard Mr. A. Bhattacharya, Learned Counsel for the applicant. Also heard Mr. What is your name?
DJ Sharma.
DJ.
DJ.
G.J. Sharma, learned counsel for the respondent number 1, 2, and 3 / claimants. Also Miss M. Saikya, appearing for respondent number 5. Stop. This interlocutory application has been filed by the applicant insurance company, namely namely Cholamandalam MS General Insurance Company Limited, praying for condonation of delay of 68 days in filing the connected MAC appeal, wherein the judgment and award dated 27/6/2024 passed in MSC case number 23/2021 within bracket D has been impugned. Stop. Learned counsel for the claimant respondent. You have any objection? As well as learned counsel for respondent number 5 submits that considering the grounds stated in the instant interlocutory application, they do not have any objection regarding the prayer made by the applicant for condonation of delay. I have gone through the grounds stated in the application. Considering the said grounds to be sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation, the delay of 68 days in preferring the same is hereby condoned and this interlocutory application is allowed. Registry is directed to register the connected MAC appeal and list the same for admission on after 2 weeks on 24th of June.
Can it 25 or 26?
26th of June. And item number 23.
I do not have instruction to.
No, you appear same.
I'll get the.
You take instruction.
Fine.
Heard Mr.
J. Sharma.
G.J. Sharma, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, who seeks some time for taking instruction from the respondent number.
1, 2, 3.
No.
Insurance 1.
Respondent number 1, insurance company, for appearing on their behalf in this case. The prayer is allowed. Also Miss M. Saikya, appearing for respondent number 3, as well as Mr. M. Mandal, appearing for respondent number 2.
My appeal was already admitted.
Okay. It appears that AD card issued along with the notice sent to respondent number 4 by speed post have been received back. Hence, notice issued to respondent number 4 is also held to be duly served on him. You take instruction, we will fix it on the same day. Let this matter be listed again on 26th June.
A copy of their appeal.
Furnish the copy of your memo of appeal. I am taking a short break.
Okay.
Service of notice upon respondent number 1 is.
Yes. Heard Mr. What is your name?
A.R.
A.R. Mandal, learned counsel for the appellant. Also Mr. P.M. Talukdar, appearing for respondent number 2. On perusal of the office note dated 18/5/2026, it appears that notice issued to respondent number 1 has been received back with postal endorsement within inverted comma not found. What will you do? You take fresh steps. Not found. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July.
We respond number 1.
Yes, respondent number 1. Respondent number 1.
Item 25.
Wait, please. An application for permitting withdrawal of the 50% of the awarded amount deposited by the respondent number 1, who is the appellant.
What happened to the main appeal?
Is admitted.
Notice.
Service is complete and NCM has also been received.
It can be listed for hearing.
Yes.
Heard Miss M. Saikya in appeal. Heard Miss M. Saikya, learned counsel for the appellant. Also heard Mr. A. Ganguly, appearing for the respondent claimants, as well as Mr. J. Kolita, appearing for respondent number 4, and Mr. S. P. Sharma, appearing for respondent number. Respondent. Who is our interviewing?
Respondent number 4, we appeal.
Both are appearing. Both are appearing. So who will be appearing? You decide among. We'll refer it to mediation.
This is, they are directed not to, there is no liability upon the original, but they are contesting to 2 advocates.
And they are not sure who is appearing.
It actually will run it for one.
Okay. It appears that notice appearance of parties in this case is complete and this matter is ready for hearing. List this matter for hearing after 4 weeks on a date to be fixed by registry. Regarding the IA,
We don't have any objection.
heard Mr. A. Ganguly, the counsel for the applicant. Also heard Ms. M. Soikya, learned counsel for the who has deposited money. You have deposited. Learned counsel for respondent number 1 company. This interlocutory application has been filed by the applicants / claimant. Applicants. One claimant is there only.
Yes.
Applicant / claimant praying for allowing the claimants applicant / claimant to withdraw the 50% of the awarded amount which has been deposited by respondent number 1 insurance company before the registry of this court in pursuant to the direction issued on 11/8/2023 in IA Civil number 4085/2024. The learned counsel for insurance company does not have any objection to the said prayer. Stop. The prayer is accordingly allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the insurance company to the claimant / applicant after proper verification. This interlocutory application is accordingly disposed of.
Item 26.
Your Lordship, this is a delay continuation petition. As per the office note, Wakalatnama has been filed by R1 to R3. They are the claimants, Your Lordship, and R4 is also the claimant, one of the claimant. But for R4 and R6, that is one of the claimant and driver, unserved notice or AD card is not arrived back. And for R5, that is the owner, notice could not be served, address could not be located, Your Lordship.
May I please, your lord?
Yes.
Your lordship, so far the delay is concerned, it is only of
32 days.
only 32 days.
And Your Lordship, a
So my
ground,
prayer is that the delay may be controlled.
You are for claimant,
Claimant.
but one more claimant is there.
Your Lordship, she's
You
the-
can appeal for, she is unmarried sister of the two. You take
I
this,
should represent her.
you appeal. Okay. Heard Miss A. Biani, learned counsel for the applicant, also heard Mr. D. Mondol, learned counsel appearing for the claimant respondent. This interlocutory application has been filed by the applicant insurance company paying for condonation of delay of 32 days in preferring the connected appeal, whereby the judgment and award dated 26/5/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MAC case number
2531.
2531/2018 has been impugned. Learned counsel for the claimant respondent submits that considering the short period of delay, he does not have any objection to the prayer made by the present applicant. The notice to other respondents is therefore waived. After going through the grounds stated in the memo in the instant interlocutory application, this court is of the considered opinion that the applicant was prevented by sufficient cause in approaching this court within the prescribed period of limitation. Accordingly, the period of 32 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected back appeal and lease the same for admission after 2 weeks on a date to be fixed by it.
My name will be reflected.
Name of Mr. D. Mondal may be reflected in the cause list as the engaged counsel for claimant respondents henceforth.
Highly advised.
Item 27.
My lord, I-27 is for petition for direct to deposit 50% from the awarded amount.
Is there any stay application?
Actually, we have filed an objection. Yes, there is a stay application and we have filed an objection document.
Objection to this? Make appeal. What happened to appeal?
Actually, the vehicle which the deceased was riding was insured by us. The scooty in which the deceased was riding and this was insured by us. But Lagat member came to a finding that the offending vehicle owned by the grief was liable for compensation. But you erroneously presume that that grief vehicle was insured by us. But that's why we are not liable in this case. We have the insurance policy. The scooty which the deceased was riding was only insured by us.
Who was at fault?
Fault was the grief vehicle.
That is the finding. Yes, Mr. Das.
Yes, my lord, on the last occasions, it was also discussed about of this fact. And the opposite party also admitted that they are the liable.
No, they are saying they are not liable.
The numbers,
Four, respondent 3 and 4. They admitted the fact.
Then,
Actually, charge sheet is given against the.
then how this insurance company may be asked to deposit 50%?
Final date may be given for
For
hearing.
hearing, lordship.
Then we are, what will happen to this interlocutory application?
Keep pending, my
Or you withdraw? Okay, we are keeping pending. In MAC appeal order लिखेंगे. Heard Miss M. Sakya, learned counsel for the appellant. Also heard Mr. B. R. Das, learned counsel for respondent number 1, 2, and
1, 2. Only 1, 2, 3.
1 and 2. It appears that notice to other respondents have been duly, it appears on perusal of office note dated 6/6/2025 that notice to other respondents have been duly served. The records of relevant MSC case has also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 28.
I is filed, my lord, for the direction to deposit 50% from the awarded amount, my lord.
Stays there.
It has been disposed of, lordship, by order dated 5/12/2025. There was no direction to deposit any amount. We don't have any liability in this case.
Appeal. What happened to appeal? Why you don't have any liability?
But the deceased was flying in a tractor as a passenger, and he was not covered under the policy of insurance.
What happened to appeal? What is the status?
Respondent, the note, as per note, office note dated 18/5/2026. No AD card, as well as no answer notice has come back. On respondent number 3.
Heard Mr. S. Sharma, learned counsel for the appellant in appeal. Also heard Mr. B. R. Das, learned counsel for respondent number. Respondent number 1 and 2.
One and two, my lord.
Who is appearing for 4?
He is appeared from some other admin level. They are represented.
By whom?
The costly, the name was shown.
A. Kakut. Okay.
4.
It appears that name of Mr. 1 A. Kakoti, learned counsel, has been reflected as in the cause letter as engaged counsel for respondent number 4. Notice issued to respondent number 3 has not yet been returned. The registry is directed to place the postal track consignment report of notice sent to. No, it will not be available. What will happen to notice to respondent number 3? You take fresh steps. The appellant is directed to take fresh steps for issuance of notice upon respondent number 3 by speed post within a week from the date of this order, returnable on 22nd July. You file, if you have any objection in the IA, you file written objection. In IA, Mr. S. Sharma, learned counsel for the applicant, heard Mr. B. R. Das, learned counsel for the applicant, also heard Mr. S. Sharma, learned counsel for the applicant insurance company, who praised for allowing some time for filing written objection against the prayer made by the applicant. Prayer is allowed. Let this matter be listed on the same date, 22nd July.
Item 29.
Yes,
My lord, I have appearing on behalf of the sole respondent. Service is ready, my lord. Let the matter be fixed for hearing.
heard Miss, what is her name? JH TH Mirapal. Appearing on behalf of Mr. S. Bishwas, learned counsel for the appellants. Also Mr. S. K. Ghosh, learned counsel for the sole respondent. Records, I say. Records will be necessary. Record will be necessary. What was done? Provide was granted. It appears that the records of the trial court have not yet been received. Issue reminder for the same. List this matter for hearing after 4 weeks on receipt of the trial court records.
Item 30.
Please, Your Lordship. As per office law dated 25/26, notice of respondent number 2 was received by his wife and notice of respondent number 3 was duly served. NCR has already been received, Lordship.
1. Mr. S.R. Gogoi heard Ms. M. Soikia, learned counsel for the appellant. Also Mr. S.R. Gogoi, learned counsel for respondent number 1. On perusal of the office note dated dated 25/2026, it appears that notice issued to respondent number 2 and 3 have been duly served. Stop. It also appears that the records of MAC case number 42/2023 has already been received from the concerned tribunal. This appeal is therefore ready for hearing. List the same for hearing after 4 weeks on a date to be fixed by registry.
Item 31.
The other side APR, PCR has also received. But otherwise the case is ready for hearing.
Lord Mr. M. Khan, learned counsel for the appellant, also heard Ms. I. Das, R. Das, appearing for respondent number,
So respondent.
appearing for the sole respondent. It also appears from the office note dated dated 6/4/2026. that the records of MAC case number 117/2018 have been received. The appeal is ready for hearing. List the same for hearing after 4 weeks on it. Date at the 8th of September.
Item 32.
Yes,
Chip, we have already taken the step. Registry was directed for consignment.
Miss D. Hajurika. How many respondents are there? Learned counsel for the appellant. On perusal of the office note, it appears that notice issued to respondent number 1 has returned with a report within inverted comma insufficient address. Insufficient address, what will you do? Stop. Learned counsel for the appellant prays for some time for finding the correct address of the respondent number 1 and thereafter to take fresh steps upon the respondent number 1 on the correct address. The prayer is allowed. The appellant shall take steps, shall try to find out the correct address of the respondent number 1 and take fresh steps on the said respondent within 15 days from the date of this order, returnable on 24th July.
Item 33.
Okay, as far as this was dated 25/26, service report may be awaited.
Mr. A.J. Cycle and counsel for the appellant. It appears that notice to respondents have not yet been returned back. The registry is directed to place the postal track consignment or notices issued to respondent number 1, 5, and 7 by speed post before this court on the next date fixed. List the matter again on 15th of June.
Item 34. In this case, when I observed as per office note dated 14/5, service is complete upon respond number 1, 2, and 4. And service on respond number 3 on the way to address it. LCR not received.
Mr. A. Bhattacharya. On perusal of the learned counsel for the appellant. On perusal of office note dated 14/5/2026, it appears that respondent notice issued to respondent number 1, 2, and 4 have been duly served on the said respondents. However, service report in respect of respondent number 3 is still awaited. The registry is directed to place postal track consignment report of notices issued to respondent number 3 by speed post before this court on the next date fixed. That this matter will list 15th of June.
Right. Item 35. Hearing this case, I am appearing on behalf of Mr. T. Kolita. May kindly grant us some time to take steps.
Mr. A. Bhattacharya appearing on behalf of Mr. T. Kolita, learned counsel for the appellant. He submits that the appellant could not take steps as was directed by this court due to some difficulty and prays for some more time for doing so. Stop, the prayer is allowed. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July.
If we are not.
The office notes now. The registry shall issue reminder for the records of the concerned motor accident claims tribunal.
While order dated 6/3/26, notices were issued, but the appeal was not admitted.
This appeal is admitted. Stop. After considering the submissions made by learned counsel for the appellant and after going through the memo of appeal, this appeal is admitted. In this you give थोड़ा ऊपर देना. Okay.
Item 36.
May I please be lordship? According to office note dated 19/5/26, LCR is not received lordship and service report of R1, R2, R3 is awaited. Also, the AD card of R2 and R3 is awaited, so postal tracking may be required.
Heard Mr. A. Agarwal, learned counsel for the appellant. On perusal of the office note dated 19/5/2026, it appears that the service report in respect of notices issued to the respondents is awaited. Stop. The registry is directed to place the postal track consignment report of the notices issued to the respondents by speed post on this before this court on the next date fixed. The registry is also directed to issue reminder for the records of the MAC case number 1865/2025, 2021.
Lordship, the notice of R1 is returned saying that addressee has left, so we may be allowed some time to take fresh steps on R1 is the insurance.
It also appears that it also appears from the office note that the notice issued to the respondent number 1 has been received back with a postal endorsement within bracket addressee left. Stop. The learned counsel for the appellant praised for allowing what?
1 week.
Fresh.
Fresh.
Praised for allowing the appellant to take fresh steps on the respondent number 1. Prayer is allowed.
Speed.
The appellant shall do so by speed post within a week from the date of this order, returnable 24th July.
Item 37.
Yes, lordship, according to office note dated 19/5/26, LCR is not received, so reminder may be asked and service is complete.
Mr. A. Agarwal, learned counsel for the appellant. Also, Miss B. Thakuria.
P. Bora appearing on behalf of Mr. P. Hazarika.
Miss
P. Bora.
P. Bora appearing on behalf of Mr. B. Hazarika, learned counsel for respondent number 3, as well as Mr. A. Khan appearing for 1 and 2, respondent number 1 and 2. It appears from office note dated 19/5/2026 that the records of MAC case number 2832/19 have not yet been received. Issue reminder for the same registry to do so. Let this matter be listed again on 22nd July.
Item 38.
Yes.
One and two have appeared.
How many respondents are there?
Six respondents. I am appearing for one and two. Claimant is appearing versus others. What's usual and registered for?
Respondent number 4 has returned without service. Heard Mr. J. Kolita, learned counsel for the appellant. Also heard Mr. M. Khan, appearing for respondent number 1 and 2. Office note dated 25/2026 shows that the notice issued to respondent number 4 has returned without service, whereas the notice issued to respondent number 3, 5, and 6 have not yet returned. The registry is directed to place postal track consignment report of notices issued to respondent number 3, 5, and 6 by speed post before this court on the next date fixed. The appellant is also directed to take. What will you do as regards 4?
I will ask what procedure and register.
Speed post. Again, directed to take fresh steps for issuance of notice to respondent number 4 by speed post within 7 days from the date of this order, returnable on 24th July.
There is an IA.
IA is your IA.
Only for the suspension of the award was state award was taken. And basically that's it. The learned tribunal has awarded rupees 4 lakhs for speech. Because by the 50/50 amount is directed to be paid, and the amount which is liable to pay by the appellant is directed to be recovered from the respondent number 4 and 5. That is honor comes. At the time of that alleged accident lawsuit, there was no federal insurance policy. It was expired long back, more than 1 year ago. On that policy lawsuit, we have filed this claim petition. So we are not at all liable to pay any compensation. That is a basic grounds in the appeal also. That is why let the matter be heard finally lawsuit, we are not possible to consider whether we are liable to pay any compensation. Pay and recovery has already. Pay and recovery different issue lawsuit. Where lawsuit, there is some technical difficulties like driving license, permit and all is there.
Whether any stay has been granted.
They want proceed time.
You go for execution.
Lot. Your lot is not. Is to stay there.
We are not staying. No.
Because we don't have any liabilities. This is
Okay.
not a technical.
That we will consider in appeal.
Lot.
We are not passing any order in IA now.
Item 39.
Obliged.
Please, your lordship. As part of office note dated 18/5/26, await for service report upon respondent number 1 and 2, lordship. And LCR awaited.
Heard Miss K.L.R. Yanthang, learned counsel for the appellant. On perusal of the office note. Office note dated 18/5/2026, it appears that service report in respect of notices sent to respondent number 1 and 2 is still awaited. Are still awaited. Stop. The registry is directed to place the postal track consignment reports of the notices sent to respondent number 1 and 2 by speed post before this court on the next date fixed. Registry shall also issue reminder for the records of the concerned motor accident claims tribunal. Let this matter be listed again on 27 July.
Item 40.
Service is awaited in all the respondent.
Heard Ms. L. Sharma, learned counsel for the appellant. The service report in respect of notices issued to the respondents is awaited. Registry is directed to place the postal track consignment report of notices sent to the respondents by speed post on the next date fixed. Let this matter be listed. 17th of June.
Item 41.
May I please your lordship, as per office note dated 19/5, both the ID cards and LCR is awaited.
Ms. P. Fukon, learned counsel for the appellant. On perusal of the office note dated 19/5/2026, this service report, it appears that the service report in respect of notices issued to respondents are awaited. The registry is directed to place the postal track consignment report of notices sent to the respondents by speed post before this court on the next date fixed. The registry is also directed to issue reminder for the trial court records list on 27 July.
Item 42.
Lordship finally see the office note dated 25/2026. The service report for respondent number 1 and 3 are awaited. And the service for respondent number 2 is completed. LCR is awaited.
Heard Ms. B. Sharma,
S. Patwari.
sorry. Heard Ms. S. Patwari, learned counsel for the appellant. On perusal of the office note dated 25/2026, it appears that notice issued to respondent number 2 has been served, whereas service report in respect of notices issued to respondent number 1 and 3 is still awaited. The registry is directed to place the postal track consignment report of notices sent to respondent number 1 and 3 by speed post before this court on the next date fixed. The registry is also directed to issue reminder for trial court records. Let this matter be listed 27 July.
Item 43.
Will be taken as I has not come.
At 2. At 2 we'll take it.
Item 44.
I have filed a IM for withdrawing the amount which already deposited before the MSCT board peta. During pendency of the MSC appeal, my lord, the claimant number 1 already died, my lord, but it is never communicated to the at the progress of that point of time. Ultimately,
What happened to appeal?
appeal, my lord, appeal allowed, my lord. Kindly see, my lord, annexure 16.
Appeal is allowed.
Allowed, and subsequently, my lord, amount already deposited by the insurance company before the MSCT, my lord. Board
Good.
peta.
If
But-
appeal is allowed, why this interlocutory application is required?
But
You-
my lord, claimant number 1 already died, my lord, during pendency of the appeal, my lord. And I am the claimant number 2, my lord. Direction, my lord, kindly see, my lord, page 19, my lord. Paragraph 11, 10, my lord. As the claimant number 1 already died, my lord, and there is no, my lord, legal heirs of the deceased, my lord. And claimant number 2 only the legal heirs, my lord. Next of kin.
Who is claimant number 2? Wife?
Is the mother, my lord.
Mother?
Mother. And claimant number one is the my lord, the father, my lord, who already died in the year 2016, my lord.
But you can pray before the claims tribunal also. Is it not disbursing the amount to you? You are one of the claimant.
One, my lord. Claimant number.
To whom award was given?
Kindly see, my lord, paragraph number, page 19, my lord, claimants, my lord, in the name of claimants.
Respondent number one shall satisfy the above award. Paragraph,
Paragraph 10, my lord.
read it.
The respondent number one, Oriental Insurance Company shall satisfy the above award of rupees 6,34,800 along with interest fixed by the tribunal from the date of filing of the claim petition by depositing the same with the tribunal within 6 weeks. It is made clear that the amount of usurper shall not carry any interest. The amount, if any, paid in the meantime towards satisfaction of the award shall stand adjusted subsequently. Paragraph number 11. The tribunal shall ensure that 50% of awarded amount to be fixed deposited in the name of claimants in a nationalized bank for a period of 2 years and 20% awarded amount to be fixed deposited in the name of the claimants in the nationalized bank for a period of 6 months. The appeal stand allowed. And thereafter, my lord, the insurance company, my lord, deposited the amount. Kindly see, my lord, page 22.
Then you approached before the tribunal or not?
No, my lord, I have not appeared.
Why you approached before the tribunal?
But this honorable court already directed, my lord,
What?
to pay the claimants, my lord.
So why further direction is necessary?
But as the, my lord, the claimant number already died, my lord.
You inform the tribunal that the claimant number one has expired.
So, it is, my lord, or I have not submitted any petition, my lord.
No, unless you go before the tribunal, why it will disperse? You appear before the tribunal. I'm giving that direction. Because what was the necessity of filing this interlocutory application?
The claimant number two, my lord, murder, my lord.
No, I am
Claimant
not
number is the
understanding. The appeal was allowed. Direction was given to disburse the amount to the claimants. One of the claimant died. One of the claimants died. You are remaining. You appear before the tribunal and tell the tribunal that I am the sole surviving. I am claimant also as well as the legal heir of the deceased claimant also. That prayer you have to make before the tribunal.
That is given, my lord, to approach that.
Heard Mr. K.R. Palkiri. This interlocutory application has been filed by the applicant, namely Lal Bhanu, alias Lal Bhanu Khatun, who is one of the claimant in
MSC case number
MSC case number
80/2009.
80/2009. Learned counsel for the applicant submits that the present applicant, along with her husband, late Muhammad Jalaluddin, had filed a claim application under section 166 of the Motor Vehicles Act before the Motor Accident Claims Tribunal, Borpeta, seeking compensation for death of their son in a motor vehicular accident on 9/1/2009. He further submits that said claim application was allowed or dismissed.
Allowed, my lord.
Allowed by the Motor Accident Claims Tribunal by its judgment dated 2012-2011, passed in MSC case number 80/2009, whereby a total
69.
amount of rupees 1,69,000 was awarded to the claimants along with an interest at the rate of rupees at the rate of 6% per annum, being aggrieved with by the quantum of compensation awarded in the said claim case. The husband of the claimant, the present appellants, the present applicant along with her husband preferred an appeal before this court, which was registered as MSC Appeal number 77/2012. Thereafter, by judgment and award date,
15/5.
judgment and order dated 15/5/2018, said appeal was disposed of by granting an enhanced compensation of rupees 6,35,000. Any interest? 6,35,000 to the claimants, out of which 50% of the awarded amount was directed to be deposited in a nationalized bank for a period of 2 years, and 20% of the awarded amount was directed to be deposited in the names of claimant for 6 months. Learned counsel for the applicant has submitted that in pursuant to the directions of this court, the insurance company has deposited the awarded amount before the Motor Accident Claims Tribunal, Borpeta, on
11/4.
on
11/4/2025.
on 11/4/2025. He submits that, however, in the meanwhile, on 3/1/2016,
16.
2016, the husband of the present applicant has expired. She submits that he further submits that as the present applicant is the sole, there is no other reason.
Married daughter, my lord, but in the next of kin already mother, my lord, stated, my lord, case 24.
Is the legal representative of the deceased husband, in support of which he has furnished a next of kin certificate. He submits that the Motor Accident Claims Tribunal, Borpeta, may be directed to disburse the said amount, disburse the awarded amount to the present applicant. On a pointed query posed by this court to the learned counsel for the applicant as to whether the applicant has approached Motor Accident Claims Tribunal seeking disbursement of the said awarded amount or not. The learned counsel has answered in negative. This court is of the considered opinion that this interlocutory application has been filed prematurely by the claimant, and it can, as it has not approached the Motor Accident Claims Tribunal seeking disbursement of the awarded amount. The applicant may approach the Motor Accident Claims Tribunal, Barpeta, seeking disbursement of the awarded amount to her, and may file an application before the said claims tribunal. On filing of such an application, the Motor Accident Claims Tribunal, Barpeta, shall disburse the awarded amount to the present applicant / claimant after proper verification. This interlocutory application is accordingly disposed of.
Alright.
Yes, we'll issue notice.
Yes, Lordship.
What's your name?
Vikono Kiso, counsel for the review applicant.
Heard. Miss. The right hand name. Learned counsel for the applicant. This interlocutory application has been filed by the applicant Srimati Sungmo Chang, praying for condonation of delay of 115 days in preferring the connected review application, whereby the applicant intends to review. Applicant is praying for review of the judgment dated 26/2025 passed by this court in writ petition civil number 69/2018. Issue notice to the anybody appearing for the other side? No.
No, Lordship, but I've already served the copy to the counsel.
To whom?
To the counsel for the respondents, in all the respondents.
Learned counsel for the applicant submits that she has already served notice to the learned counsel for all the respondents. Hence, formal notice need not to be issued again. Let this matter be laid. They may file, the respondent side may file written objection if they desire to do so. Let this matter be listed again at the day on 24th of June.
Yes, Lordship.
Item 1 pertaining to isolvents.
Please, Your Lordship.
Yes.
My lord, this is the second time the petitioner has approached this honorable court for his enlargement on bail. My lord, the first time was that lordship has remanded the matter to be heard by the sessions judge at Lunglei, since there is a pending bail application. I hope lordship remembers it.
What happened there?
And the same was rejected, my lord, on the 28th of April 2026.
What is your ground now?
My lord, the main contention is that there has not been, the petitioner, the applicant has not been furnished the grounds of his harass in writing, which is a which is a which is a judicial mandate at this stage, as various Supreme Court judgments and has settled that communicating the grounds of arrest is a mandatory requirement and a part of the fundamental rights under Article 22 of the Constitution of India. And my
Where
lord,
is the- You have not served with any notice under section 47?
yes, my lord. No, my lord.
Yes, Miss Linda.
My lord, I will have to call for the records, my lord, in this case.
Okay.
Charge sheet is already filed, so.
Heard Miss Lalrokung Pautu, learned counsel for the petitioner. This petition under section 483 of the BNSS has been preferred by the petitioner for the second time. No, preferred by the petitioner seeking bail in connection with NDPS criminal trial within bracket NDPS number 298/2023. The petitioner is mainly seeking bail on the ground that he has not been communicated in writing the grounds of his arrest. Stop. Considering the contention raised by the petitioner, perusal of the trial court records as well as connected case diary would be necessary. Hence, let the scanned copy of the trial court records and connected case diary be called for. Registry to do so.
My lord.
Yes.
Connected case diary, my lord, it should be the trial court records because charge sheet is already filed, my lord.
No, along with that case diary will also be there.
All right.
So we are only asking for scanned copies.
Okay, all right.
When can you produce?
My lord, I think it has to be called from the registry if it's the
Yes.
trial court
When can
records.
we fix?
After a week, my lord, since it's in Lunglei district.
Let this at the date the oxide. Let this matter be listed again on 19th of June.
19th of June, all right.
My lord, can the matter be, my lord,
19th is Friday.
it's actually, my lord, he has been incarcerated for around 206
No, what is
years,
your prayer?
265 days, my lord. So if the matter can be expedited, I'm sorry to say, my lord, can the matter be fixed on the, at least on the 9th, my lord?
Date. When?
On the 9th of June, my lord.
Okay, 9th of June.
All right.
My lord. I'm grateful.
Obliged.
Item 1.
I had taken the instruction, madam. They are willing to participate in the mediation.
Yes.
Okay.
Heard Mr. S. Das, learned counsel for the appellants. Also heard Mr. R. K. Jain, learned counsel appearing for all respondents. After going through the materials available on record and after hearing learned counsel for both sides, it appears that parties in this case are related to each other and there is a possibility of arriving at an amicable settlement between them. Hence, this matter is referred to mediation. The parties shall appear before the mediation, before the appointed mediator in the mediation, in the Gauhati High Court Mediation Center on a date to be notified by the
The date can be fixed.
mediator. High Court will notified by the said mediator. The report of mediation, a report by the mediator shall be submitted before this court. How much time?
After vacation, madam.
Yeah, the date there.
Too much time.
August.
Submitted before the court on 4th of August. 4th of August. List accordingly.
Hello.
Item 4.
If you Lordship,
Yes.
Lordship, this is a case, Lordship, where I have filed a title suit against my brother and my father, who is suffering from dementia. And he is a pro forma defendant only, Lordship. My contention was that the property which belongs to my father, I wanted to safeguard it from my brother. Now, because of that, Lordship, I have filed an title suit. Along with that, I have filed an application for stay, and also I have filed an application under Order 32, Rule 15 for appointment of me as a guardian. These matters are pending before the court, and while considering the prayer for injunction, my injunction was not granted, and that is why I have come before the Honorable.
No notice was issued. When is the next date fixed?
Next date was fixed yesterday, Lordship.
What happened?
There nothing, no date is given till now, no order is passed till now. I have checked with before coming, I have checked with
Whether the other side appeared or not?
they have not appeared. My Lordship, I am not asking something out of the, all I am asking that whatever rent is given, like the normal process, you kindly deposit the rent in the joint account which we have. That's it. And nothing, at this stage, I am not asking for anything more. Let them come and then we will have a talk regarding that, Lordship. That is all I want. And there will be no harm caused to any of the parties if such kind of order is passed.
No, but the nature of relief which you are seeking, other side is required to be heard.
So, Lordship,
And it is not in an urgent relief,
Lordship,
because it will be deposited after end of the month. We are, today is,
Lordship, may kindly turn to page number 13. If that, I was restraining myself to that extent only, but that is not the thing here.
if you,
Page number 13 of the IA, Lordship.
I,
Page number 14 maybe see. The kind of thing which is happening. Para number 17, it starts.
no, we are not saying that you don't have a case.
No,
But
my
only question
then-
is,
In that, then para number 21. Para number next page.
that is it a case where on the back of the other side, we should issue?
Yes, Lordship, what I'm trying to say, Lordship. Tomorrow, if there is a specific case in page number 15, para number 20.
Page number?
Page number 15, para number 21.
Yes.
The petitioner humbly states that if the current state of affairs is permitted to continue, then there is a grave and well-found apprehension that the defense, respondent number 1 and 2, by taking undue advantage of the advanced diminished.
No, this is.
And resulting in
Yes.
And resulting mental condition of the pro forma defendant are attempted to illegally alienate the suit property.
This is
The fear-
mere apprehension.
Lordship, that apprehension leads to filing of an injunction, Lordship. Whenever I have an
But
apprehension.
there has to be some basis.
The basis is that, Lordship, they have already forged the signature. This is not something which is, I'm saying, out of the blue. Your Lordship may kindly see this annexure. It will itself prove.
You are appearing for
For the bank, Lordship.
how bank is involved?
My name is there, Your Lordship. Bank is involved because they have opened the account in that specific bank, but I have no relief asking them. There is no relief I'm claiming against that. Lordship. But in the title suit, I have made them a party because the account which is there-
Here, what interim relief you are seeking?
Lordship,
Let us see your prayer.
yes, Lordship. Page number 21. Temporary injunction restraining the respondent number 1 and 2 and their men and agent from entering into
No,
any
yesterday what happened in the,
Yesterday, Lordship, the order I have represented, the opposite party has not come, and till now the order is not uploaded. I went at 10:30 in the morning. The order was not passed. The next date is also not given. I can clarify it right now by seeing in the portal, Lordship. Till now, I have checked it at 1 o'clock today. The order is not passed, and the date was yesterday.
Now, what relief you are seeking here?
Lordship, I have around five prayers that I have.
What is the,
I may read it out, Lordship.
no.
I have two.
What relief you think that
Lordship.
would
Lordship,
the
three-
granting of purpose of
First,
granting relief would be frustrated by issuance of notice? Which one is that kind of relief?
First is that Lordship takes the signature, he may not enter into any signature on behalf of my father. Or my father may not execute anything because right now his mental condition is not there. He cannot put signature. I have filed a police case also. I am serving in the army. I am always outside. My entire property he have taken over. It might not be that it's a Benami property, Lordship. His name is there, but he's not the owner. He's a dementia patient. My brother is executing everything. Today, if he makes a will, or if he has already made a will, then tomorrow, if he dies, nothing will happen. My entire thing will be lost. Then I have to again contest the probate.
Who is pro forma defendant number 6?
My father, Lord, who is suffering from dementia, and I have no claim against him. I'm asking.
Okay, one prayer one, and prayer one will grant. Anything else?
Prayer 2, Lordship, that prayer 2 is also there. Injunction covering the pro forma defendant number 6 who is suffering from dementia and is of unsound mind to execute any will or gift or deed or any agreement with respect to the suit land. Now, nowadays, what is happening, Lordship, I have required, if I have to file for guardianship, then there is a specific tribunal which has been formed. It is not the district judge anymore. So I have to go there asking, otherwise I have recourse to Order 32, Rule 15 of the CPC, Lordship. And which I have already taken steps, Lordship, in this case. Now, prayer number 3, Lordship, prayer number 3, page number 21.
No, 3 is not so. Heard Mr. P. Deka in FAO. Heard Mr. P. Deka, learned counsel for the appellant. Also heard Mr. What is your name? M. Sharma, appearing for respondent number 3 and 5. This appeal under Order 43, Rule 1, within bracket small r of the Code of Civil Procedure, has been preferred by Lieutenant Colonel Akshay Das, impugning the order dated 31/3/2026, passed by the Learned Civil Judge Senior Division, passed by the Court of Learned Civil Judge Senior Division, number 1 Kamrup Metro in Miss J case number 381/2026 in connection with title suit number 200/2026, whereby the trial court did not grant any ex parte ad interim injunction as was prayed by the present appellant, and instead issued notice in the aforesaid miss case. Learned, stopping. Issue notice to the respondents. Since Mr. Sharma has already appeared for respondent number 3 and 4, 3, 4 and 5. 3 and 5. No formal notice need to be sent to the said respondent. However, the appellant shall furnish requisite copies of the memo of appeal along with annexures to the said respondent, to the learned counsel for the said respondent within the course of the day, within a period of 2 days from the date of this order. As regards other respondents, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the within it by tomorrow, if you are getting interim relief, by tomorrow, returnable on 24th July. It may be in June. Returnable on 24th June. Stop. Next, in the interlocutory application. This interlocutory application has been filed under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure for issuance of temporary injunction during the pendency, temporary injunction against the respondents during the pendency of the connected first appeal against order number 29/2026. Learned counsel for the applicant has submitted that the pro forma defendant in the suit filed by the present applicant before the trial court is his father, is the father of the present applicant as well as of the respondent number 1. Respondent number 1. He submits that the father is presently suffering from dementia and taking advantage of the said condition of his father, the respondent number 1 has forged the signature of his father and siphoned off funds from where?
Joint account into newly opened undisclosed account.
Funds from joint account in the name of the present applicant and respondents in the newly opened account of in the name of
His father and himself.
his father in the name of pro forma defendant and respondent number 1. He submits that
He is operating the account through the mobile phone of his father.
since the pro forma respondent father is presently with the respondent number 1, the respondent number 1 is operating the mobile which is in the name of his father and using the same for operating the newly opened account. As such, where is the apprehension?
Page number 14, para number 17.
As such,
17, 18, 19.
as such, unless the respondent number 1 is injuncted, he would continue unauthorized access to the device of mobile device of the pro forma respondent within bracket father of the present applicant. He submits that learned counsel for the applicant further submits that the medical condition of the pro forma respondent number 6 within bracket father of the present applicant is in the state of progressive decline and has worsened due to systematic neglect and lack of basic care by the respondent number 1. Under such circumstance, learned counsel for the applicant submits that under such circumstances, the applicant genuinely apprehends that respondents number who is 2 wife
Wife.
respondent number 1 and 2 by taking advantage of the health condition, that is advanced dementia of respondent number 6, may illegally alienate the suit property by forging his signatures
Or thumb impression.
or thumb impression, and therefore unless the respondent number 1 and 2 are injuncted during the period of notice issued to them in this interlocutory application, the petitioner would suffer irreparable loss and injury. He also submits that no, stop. There is also an apprehension that taking advantage of the mental health condition of the respondent number, pro forma respondent number 6, the respondent number 1 and 2 may also coerce the pro forma respondent 6 to execute any will or gift or any other agreement in respect of the suit land and suit property as described in Schedule A and Schedule B. You have given schedule in this
Yes.
stuff. Issue notice to the
Schedule is in page number 26.
notice to the respondents in this interlocutory application. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 24 hours of the date of this order, returnable on 24th June. Stop. In the meanwhile, considering the submissions made by learned counsel for the applicant as discussed in the foregoing paragraph, the till returnable date, the respondent number 1 and 2 are restrained from alienating the suit property and suit land and suit property as described in Schedule A and Schedule B in any manner to any third party. The said respondents are also injuncted from coercing the respondent number 6 to execute any will or gift, deed, or any other agreement in respect of this suit land described in Schedule A and suit property described in Schedule B. Stop. List this matter accordingly.
Highly approved.
Item 14.
Please, your lordship.
Yes.
Lordship, in this matter, an affidavit has been filed from their side. We have received that affidavit today itself, lordship. We need a little time to coordinate with the department with regard to that and obtain instruction.
Since before filing this affidavit, they requested me for time. So this is an excuse because this affidavit.
When have you filed affidavit?
I filed this affidavit, I've given a copy yesterday itself to them.
But we
But
have
this
received-
affidavit does not speak of anything except certain documents which are on record. Because the LCR is before this court. More than 1 year, 6 months, this man is languishing. It has been more than 1 month back notices was issued and it was,
What is your ground in this appeal? In
One-
this?
my lord, I have 3 primary grounds, my lord. One is beyond 24 hours.
Okay.
What
Let
I-
them, let us give them 1 week time. Sure.
Objection in this matter. The reason for the delay is the operating IO was outstation.
Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Ms. R. Hussain, learned counsel for NCB
Lordship, DRI.
and DRI, who submits that the respondent has received the copy of additional affidavit filed by the petitioner today only. And in this regard, they need to take instruction from the department concerned, and if necessary, to file a written objection against the same. The prayer is allowed. Let this matter be listed again on
28.
28.
28 is not a holiday, 27 is a holiday.
Short.
Lordship, 29th.
3rd June.
Lordship.
3rd June.
My lord, hard June is too long, my lord, because my lord, he is in detention for such a long time. And they have got more than 1 month. It is not that today I am moving it. On 29, let it be on 29. She has paid for 29. She paid for 29.
Okay, 29.
Item 43 and production list item 1.
Yes, Mr. Gupta.
I put a modification on the order dated 8/4/2026.
Huh?
Modification of the order dated 8/4/2026. In this case, Lordship, a stay was granted subject to deposit of 50% of the awarded amount. Lordship, in the meantime, Lordship, we deposit 25% amount, Lordship, before the tribunal, Lordship. So, Lordship, that is why, Lordship, we, Lordship, want to modify the order, Lordship, so that we can deposit 25% less 25% before the adjusting the amount into the registry, Lordship.
You have already deposited 25%.
Yes, Lordship, before the tribunal, Lordship.
Yes, Mr. Bhardwaj.
Been told that they have deposited 25%, so in my lord, the rest remaining 25% if they pay within 2 weeks. Yes, yes.
Heard Mr. K. K. Bhatto, learned counsel for the applicant in IA. Huh? And learned counsel for the applicant. Also heard Mr. G. Bhardwaj, learned counsel for respondent number 1 and 2. Miss M. Chaudhary appearing for respondent number 5, and Mr. Who is appearing for 3 and 4? No one. 1 and 2. Respondent number 5. M. Chaudhary for respondent number 5. This interlocutory application has been filed in connection with, has been filed by the applicant insurance company in connection with IA civil number 1140/2026 in connection with MAC case number 161/2026, whereby the applicant insurance company was directed to deposit stay directed which
140.
directed to deposit 50% of the awarded amount before the registry of this court as a condition for grant of stay of the judgment and award which has been impugned in the connected MAC appeal number 161/2026. Learned counsel for the applicant insurance company submits that in the meanwhile, the insurance company has already deposited 25% of the awarded amount before the Motor Accident Claims Tribunal, which, Tubri,
Yes.
Motor Accident Claims Tribunal, Tubri, on which date?
24/4.
On 24/4/2026. And he therefore submits that the order dated 8/4/2026 passed in IA number 1140/2026 may be modified to the extent that remaining 25% may be may be required to be paid by the insurance company before the registry of this court. Mr. G. Bhardwaj and Ms. M. Chaudhary have no objection to this. That is what I was asking. What is your name? S. Chaudhary for respondent number 3 and 4. Learned counsel for respondent do not have any objection against the said prayer. Objection against the prayer made by the applicant, hence same is allowed. Accordingly, the order dated 8/4/2026 passed in IA civil number 1140/2026 is hereby modified to the extent that the insurance company / appellant shall deposit 50% of the awarded amount as a condition for grant of stay of the execution of the impugned judgment and award within a period of 2 weeks.
25%.
No, Gili Padita. 25%, 25% of within a period of two weeks from the date of this order. This interlocutory application is accordingly disposed of. Main as it is.
The 45.
Then I am not praying for direction to deposit 50% from the awarded amount.
Main appeal sub Is there any stay?
Yes,
Stay was granted or not?
I did, my lord.
Stay. Stay. There is no stay application.
Yes, my lord, on 6/4/2026, it was directed to appellant to file this application.
No, whether the impugn award has been stayed,
Still not. No,
Eh.
stay order is not there.
then where is the necessity of issuing order for disbursement of 50%? You can go for 100%. Who is for the appellant?
Appellant side, this is the private party. It was directed to the owner of the vehicle, to the insurance company, that is a Suneshwar Das.
Appeal is filed by you.
No, my lord. IA is filed by me, appeal is filed by the, Suneshwar Das, who is the owner of the vehicle.
You go for 100%. There is no stay application.
Yes.
At this stage, we are not passing any order on this. If they file an interlocutory application for stay, then we will consider. None has appeared for the appellant on call. Mr. B.R. Das is present on B.R. Das Learned Counsel for respondent number 1 is present. On perusal of the office note, it appears that notice issued to respondent number 4 and 5 is have not notices issued to respondent number 4 and 5 have not yet returned. Awaits no. The registry is directed to lay the postal track consignment report of notices issued to respondent number 4 and 5 before this court on the next date fixed. Let this matter be listed 17th of June.
Can it be fixed on 27 June?
27 June.
Yes.
Okay.
Item 46.
Yes.
May it please your lordship.
Total main appeal local tibuk. Yes, what has happened in the appeal?
My lord, the learned, may I place the facts to the
No. How many respondents are there?
3 respondents.
You are appearing for all
I'm appearing for respondent number 1.
2 and 3.
We have to form our respondent.
So this appeal can be heard for final disposal
Yes.
today.
As it is the ex parte ad interim injunction, which was granted in my favor by the trial court, was modified by your lordship to a status quo in both parties.
Okay.
So, my lords, now only thing remains is to be the missed cases to be decided by the learned trial court. So my humble submission would be, my lord, the matter may be remanded back for hearing the missed cases, the applications heard on marriage. Right?
Now status quo, you are agreeable to status quo.
Yes.
You are also agreeable.
may I place my.
Yes.
What my friend is saying is not wrong.
the matters can go back to the lower trial court and they can file it another trial court to adjudicate the matter. But what I am on is, otherwise, I would not have had a right of appeal as against an ex parte ad interim order. I ought to have appeared there and thereafter argued the matter out there on the next day. But for the fact that my lord's order was there, the lordship takes up the order in the appeal. That is 24th of March 2026. Lordship is there.
Yes.
There we had referred to 2000 volume 7 SCC 695. That if the period of 30 days is crossed, then it becomes a final order and therefore appealable as in first appeal against orders from this honorable court. It is on that context that the appeal was admitted and the status quo order was passed. For that, I may invite my lord's attention to that. We've given this,
No. Now, the injunction was granted or not?
Injunction was granted, then they came.
Ex parte ad interim injunction was granted.
There was some flouting of the rules.
And
So-
the next date was given beyond 30 days.
So your lordship had modified it to a status quo court order. Now, there is a stay order or stay also of the proceedings
Yes.
before the trial court.
That's an inter-party order.
Only thing remains is they have given an averment in their appeal that they will file a detailed written statement and a written objection. So let them file it and we'll let the appeal.
So far as
These
we are
cases be
concerned-
decided on merit. I'm sorry.
So far as filing of written statement, written objection is concerned, it's a matter of right. Only thing is, since lordship is hearing the appeal, and the appeal is a fallout of the fact that the order of injunction will pass beyond 30 days, and the Honorable Apex Court says, which had also fallen from your lordship, that it becomes a final order and therefore appealable order. Now on the merits of the appeal, whether the injunction stays or goes, the status quo stays or goes, or how it is to be taken up.
No, but what Supreme Court says,
May I read that?
yes.
It is the act of
No, before you read, I have a query. Now, when both the parties are agreeable to maintain status quo,
Right.
is there any bar on the trial court to consider the appeal?
If I read this paragraph, perhaps lordship, I can take a call on that. As I see it,
Yes.
there may be, the list
Yes.
of books was given. So lordship is having it, 2000 volume 7 SCC. May I read that?
Yes, please.
I'm sorry. It is the acknowledged
You have
position.
given list of books
We have-
to whom? What I say? Okay, you read slowly.
It is the acknowledged position of law that no party can be forced to suffer for the inaction of the court or its omissions to act according to the procedure established by law. Under the normal circumstances, the aggrieved party can prefer an appeal only against an order passed under rules 1, 2, 2A, 4, or 10 of Order 39 of the Code in terms of Order 43, Rule 1 of the Code. He cannot approach the appellate or revisional court during the pendency of the application for grant or vacation of temporary injunction. In such circumstances, the party which does not get justice due to inaction of the court in the following mandate must have a remedy. So we are of the view that in a case where the mandate of Order 39, Rule 3A of the Code is flouted, the aggrieved party shall be entitled to the right of appeal, notwithstanding the pendency of the application for grant or vacation of temporary injunction against the order remaining in force. In such appeal, if preferred, the appellate court shall be obliged to entertain the appeal and further to take note of the omission of the subordinate court in compliance with the provisions of Rule 3A. In appropriate cases, the appellate court, apart from granting or vacating or modifying the order of such injunction, may suggest suitable action against the erring judicial officer, including recommendation to take steps for making adverse entry in the ACR. Failure to decide the application or vacate the ex parte temporary injunction shall, for the purposes of the appeal, be deemed to be the final order passed on the application for temporary injunction on the date of expiry of 30 days mentioned in the rule. In other words, that order passed by the jurisdictional court becomes a final order, hence appealable under Order 43(1)(r).
It also implies that pendencies of before that court is of no meaning.
Yes, it can, so it has two views. I'm not against what he's submitting. What I'm placing is this: either I make this submission before this honorable court, or I make this submission before.
But if you make your submission before this court, and ultimately you will be losing one forum,
we may lose a forum.
you will be losing one forum.
That's what I'm thinking now.
If you make your submission before the trial court, the aggrieved party may again come to this
Sir,
court.
That's what I'm
That
saying. We are not against, I'm not against what he's submitting. He also not against me. Only what would be the proper forum of law, because my right of appeal flows from the Honorable Apex Court saying that it becomes a final order. Once it becomes a final order, whether the jurisdictional court can still decide the injunction would be the point for consideration before your lordship now. If the answer is yes, then we go back and argue that. If the answer is no in terms of this judgment, then I have
no,
to.
it also speaks that this court can modify the order,
Correct. Because in appeal,
which has already been modified by this court before hearing both of you on.
we agreed to the status quo. It's not that I was arguing he was against. We both agreed to status quo, and I'm still agreeing to status quo. Only thing is that lordship could clarify that. We'll go back and argue them. Not an issue with that. Only this I need to, in all fairness, I need to.
Which
point
para? Para?
Possibly it was 21 towards the last lines. But I'm not even opposing what my colleague is saying. Not on that. He's also not opposing me. Only we
It's a-
address here or go there.
Discretionary power which has to be exercised by the trial court while deciding an injunction application. The Supreme Court has clearly stated in Wander Limited. Appellate court has limited, won't interfere with the.
But this is the exception.
Unless it is a perverse order.
This order is
Well,
exception.
in support of this, my lord, I'm submitting.
This ex parte ad interim beyond 30 being a final order would be an exception. I would happily go there. Milord. Only we are placing the correct position of law before.
My lord, that's paragraph 14.
Yes.
I will read from the second line. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion except where the direction has been shown to have been exercised arbitrarily, capriciously, or perversely, or where the court had ignored the settled principles of law regulating grant of refusal of interlocutory injunctions.
Para?
Paragraph 14. Wander Limited and another versus Antox, 1998 supplementary SCC 727. Has it? Paragraph 14, page 733.
Yes. Now, what is your submission? What?
Yes, exactly. What he's saying is, if my lord, as the appellate court, would find merit in what I'm submitting on the exercise of jurisdiction by the learned trial court, then of course we can go this way that. Or, as he's saying, we can all go back and address the issue there. But in these circumstances, as laid down, the law laid down by the Honorable Apex Court, would I not be pleased to hear on the facts? Whether the exercise of jurisdiction merits intervention or not. I leave it to your lordship. In fact, we both leave it to your lordship at that. Going back would be good for both of us. We'll have a forum left. Come back. That's I understand. Even this, I'm not even addressing on the merits of the matter. Neither is he. Only
No, if this court directs
yes, then go with this to your hip.
No, if this court remands back the matter,
Yes,
whether it would be against the,
yes, that can. May not be, because this remand would not be under order 23, that would not come in. This remand would be accepting the appeal by the Honorable Apex Court judgment and then directing for a consideration,
yes,
reconsideration.
yes.
At that, the point comes. Correct, that can be done, I am on that page. Whether I open up my attack or defense and he responds to that, whether it can be part of the order meriting
No,
a remand.
no, not here.
That's obliged. Then I do not address any further.
You
But the
may,
status quo to maintain,
yes, make your submissions before
sure.
trial court.
because we come back again.
Heard Mr. S. Banik, learned senior counsel, assisted by Miss F. Begum, learned counsel for the appellant. Also Mr. D. Mr. N. Patiri, learned counsel for respondent number 1, as well as Mr. J. Hatimudia, appearing for respondent number 2 and 3. This appeal under order 43 rule 1 within bracket R of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the order dated 19/2/2026 passed by the Court of Learned Senior Civil Judge Senior Division Kamrup Amingam in Misje case number 85/2026, whereby in connection with title suit number 68/2026, whereby the trial court granted ex parte ad interim injunction against the present appellants while issuing notice to them and fix the matter. When it was fixed,
12th of August.
fix the matter. No,
No.
at the first instance. Fix the matter
31/3 was first date for the injunction application.
on 31/3/2026.
And for the suit, 31/5.
Suit and injunction application same date.
No, because of different days lordship. Thereafter it went back on the suit date.
For the suit
31/5.
31/5.
and
19/5.
for
19/5, sorry.
19/5.
19/5. First date was, injunction was granted on 19/2.
2.
What was the next date?
31/3.
31/3.
31/3. Fix the matter on last line to prohibition. Fixing the case. Fixing the matter on 31/3. 2025, 2026. Learned senior counsel for the applicant has submitted that since the date for filing date of next date for since while granting the ex parte ad interim injunction, the trial court fixed the next date, that is date for appearance of the present appellants and for filing written objection by them beyond the on a date which is beyond the period of 30 days as mandated under Order 39 Rule 3A, there has been a violation of the statutory provisions, and as such, he submits that as per the observation made by the Apex Court in the case of M. Venkata Subbiah Naidu versus S. Chellappen and others, reported in 2007 SCC 695. Such an order attains finality, and same is appealable under Order 43 Rule 1R of the Code of Civil Procedure. Hence, he submits that though the trial court is yet to hear both the parties on merit, however, the order which has been impugned in this appeal has attained finality, and this court may also hear the appeal on merit. However, he fairly submits that if same is done by this court, one of the parties, the losing party, may lose one forum of appeal, which would be otherwise available to them if they agitate their case before the trial court. He further submits that this court where is the order of status quo? This court, in the connected interlocutory application number 932/2026, by order dated 24/3/2026, had directed both the parties to maintain status quo in respect of the suit property till next returnable date. Stop.
Thereafter, different order came in a different IA.
Hmm?
Thereafter, Lordship was pleased to take up IA Civil 1435 of 2026.
What is that?
Which was a consent order whereby Lordship was pleased to stay all further proceedings until disposal of the FAO, maintaining the status quo. That's all.
1435. Okay.
That was a consent order.
Okay. Thereafter, it appears that in another connected interlocutory application, that is 1435/2026, this court, by its order dated 6/5/2026, stayed the further proceeding of Ms. J case number 85/2026, where the impugned order was
And also the suit
further proceeding of
and the contempt proceeding.
further proceeding of title suit number 68/2026,
J case.
comma Ms. J case number 85/2026,
And Ms. J case 102.
as well as Ms. J case number 102/2026, pending before the trial court till the pendency of the instant first appeal. and both the parties were directed to maintain status quo in respect of the suit property. It is pertinent to mention herein that the status quo order passed by this court on 6/5/2026 was agreed to by both the parties, and it was a consent order. Today, learned counsel for both the parties have some. Now, on the other hand, Mr. N. Patiri, learned counsel for the respondent number 1, submits that the respondent is agreeable to maintain status quo as was directed by this court during the pendency of the title suit number 6. No, during the pendency of the Miss J case number 85/2026, and he praised that the matter may be remanded back to the trial court so that trial court may, after considering the contentions of both the parties, dispose of the injunction application on merits.
Next date is 12th of August. 12th of August.
So, after considering the submissions of learned counsel for both the sides, this court is of considered opinion that though in pursuant to the observation made by the apex court in the case of M. Venkata Subbiah Naidu versus S. Chelappan Supra, this court has also the jurisdiction to decide the matter on merit after hearing the rival contentions of both the sides. However, if this court chooses to do so, one of the party may lose a forum for appeal, which under the facts and circumstances of this case, when both the parties are agreeable to maintain status quo, does not seem to be appropriate. Accordingly, this case is remanded back to the trial court with you have filed a written objection
Will be open now.
to trial court with a direction to decide the Miss J case number 85/2026 on merit after giving an opportunity to the present appellant of filing written objection,
As also written statement in the suit.
as well as also filing written statement in the connected title suit number 68/2026.
And written objection in Miss J case 10.
Written objection in Miss J case number 102/2026. Stop. The stay granted on further proceedings of above mentioned cases by this court on 6/5/2026 is accordingly vacated.
The status quo to continue till disposal of the injunction application.
The status quo granted by this court in respect of this suit property, as mentioned herein above, shall continue till the pendency of the Miss J case number 85/2026.
That's all. I was thinking aloud for a moment. If Lordship permits, I may place that. That since the original order of injunction order has been modified to a status quo now, and that would continue till disposal of the injunction application. But other question I put to myself, madam, whether or not the contempt application should continue, because that was on an interim. That may be stayed.
contempt application may be stayed. I can continue. That may be stayed until disposal of injunction application. Then things will come into the main bill. Probably it will be only.
No, this prayer you can make before the
Well, that
trial
liberty
court.
may be there. I'll make it. So,
You may make that prayer.
Lordship, that since I've made that prayer before this honorable court, that observation liberty.
Learned senior counsel for the appellant has submitted that since the order passed in, since the impugn order which was passed in Ms. J case number 85/2026 has been modified by this court in the manner as described herein above, he prays for staying the Ms. J case number 102/2026, which is pending before the trial court, which was filed alleging violation of the ad interim ex parte injunction granted by the trial court. Stop. However, this court is of considered opinion that since the matter has been remanded back to the trial court, this prayer may be made by the present appellant before the trial court itself. With above observation, this appeal is disposed of.
I will submit, my lord. My agreement to the maintaining of the status quo may not affect the merits of the case before the trial. My lord. That may be recorded, my lord. Yeah, because it has been
They have to
recorded.
record on that.
There is a
Status quo is an
consent
order.
order.
Status quo order. Please, done with. The order of status quo is a consent one. We're not disputing on that.
That was
It
only
is, the remand is on that consent.
that
No,
was
it is only during the pendency of
Nothing on that.
pendency of 85.
85.
I just want a trial court might think that they
No,
have
no.
agreed for a status quo, so the missed cases will be decided as a status quo where
No, no,
the
suit
first
would-
instance I was
suit would
granted an
be-
ad interim
suit would be
injunction.
decided on issues and evidence. Suit on issues and evidence.
The
The injunction
tri-
application not on that. Matter. Status quo is only a pause button until
No,
decision of the injunction application.
if I make any
Go
observation,
here and there.
because before the trial court also you may come to an agreement of
Yes.
maintaining status quo. That is also one possibility. That 85 may also be disposed of with
Lordship.
same direction.
Can, I don't know.
Okay. But it is let it be left to the
Let it come that only the agreement was only till the disposal of the FAO, my lord.
Not a, the injunction application.
Maybe
Injunction application.
that the order which we had given consent to 6/5/2026, my lord.
Yes,
That
that
was
was
only till the disposal of this appeal, my lord.
correct.
yes.
And now we
So
consent.
that
But now it will continue till the disposal of
Very.
85.
My
That,
only worry is that the trial court might think that, okay, they have agreed for a status quo, so the
No,
merits may not be.
that has been clarified. That has been clarified that it will continue only till disposal of 85. Is 85. The connected interlocutory applications are also disposed of accordingly.
I'm grateful.
Thank you.
কিতাপখন ঘূৰাই দিয়ক।
Item 47.
Service may be avoided in this matter.
Heard Mr. S.P. Sharma, learned counsel for the applicant. On perusal of office note dated 18/5/2026, it appears that the service report in respect of the notices issued to respondents are awaited.
Taken steps on 9th of May.
Okay, await further. List this matter again on 24th of July. 40,
48.
48, same order.
Item 49.
Thank you, Josh. Does it kindly see the office note dated 25/26? there is some delay in taking stage first. Stage was taken on 16/5 and the notice issued on 19/5 to release. Further lawsuit we took stage by speed post on 21/5.
21/5 you have taken steps.
Right.
Heard Mr. M. Talukdar, learned counsel for the applicant. Stop. Though office note dated 19/5/2026 shows that the appellant has not taken steps for issuance of notice through speed post. However, learned counsel for the applicant submits that said steps were taken by the applicant on 19/5/2020.
It was taken on 16/5
16/5
by usual process and
by speed post.
speed is on 21/5.
Speed post on 21/5/2026. Stop. In view. Stop. Considering the submissions made by learned counsel, await service report. एक माह और डेट दियो 13 July. Please this matter on 30.
Item 51.
Similar prayer. And this is
Mr. M. Talukdar, learned counsel for the applicant. Who submits that though the office note dated 25/2026 indicates that the appellant is yet to take steps for service of notice by speed post, however, such steps were taken by the applicant on 21/5/2026. In view of the submissions made by learned counsel, let the service report be awaited. Let this case be listed again on 22nd July.
Item 54 from supplementary list.
Time for filing a wakalat along with a substitution petition. There is an applicant who. Right.
What is the submission?
I'm newly engaged in this.
Newly engaged.
Yes.
Okay. What is your name?
BJ Brahma.
Heard Mr. B.J. You have not filed Vakalatnama.
Yes, Lordship.
Heard Mr. B.J. Brahma, who submits that though he has been engaged by the appellants to appear in this appeal, however, he needs some more time to file Vakalatnama. In this case, if the prayer is allowed, let this matter be listed on 24th June.
Item 55.
This is complete upon Respondent number 125, my lord, 6 is awaited, my lord.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Miss M. Das, appearing on behalf of Mr. U.C. Soikia, learned counsel for 2 to 6, 1 to 6, 1 to 5.
I think they are minors, so
Okay, 1
one
to,
is represented.
1 to 5.
Ending since 2025, Lordship.
Respondent number 6, what will?
Driver matter. 6 is owner. No, my lord.
You take fresh steps.
Driver, 6 is driver matter. 6 is driver.
No, when have you taken steps? fresh steps. Take fresh steps by speed post. Six, only six. The appellant is directed to take fresh steps for issuance of notice upon respondent number 6 by speed post within 7 days from the date of this order, returnable on 17 July.
Item 56.
And question number 1.
Mr. K.K. Bhatto and the counsel for the appellant. Also heard Miss B. Das, M. Das, learned counsel for respondent number 1, as well as Mr. A.J. Saikya, appearing for respondent number 3. What is this status? Who is appearing for 2 to 4?
25, 2026, the service is completed.
Perusal of office note dated 25/2026. It appears that notice issued to respondent number 4 has been duly served. The service of notice on the respondents is complete. The records of the trial court have also been received. Hence, this matter be listed for hearing on 8th of September.
Item 57.
As per direction of this honorable court, my lord, 22/9/2025, my lord, I have taken instruction from my client. Earlier, my lord, during the trial, my lord, the both parties made an endeavor to settle the matter, but that was failed. So, my lord, my client is now, my lord, not willing to go for my lord mediation. Lordship may fix this matter for hearing, my lord, final dismissal.
Lordship, at least 50% of the awarded amount is insurance.
But there is no stay, my lord, that's right.
You are for the insurance company.
No, my lord. If for the, my lord, owner of the.
You go for 100%, file execution case against him. Otherwise, we are fixing this for hearing. Heard Mr. R. Sharma, learned counsel for the appellants. Also heard Ms. P. Das. What's your name? R. Datta, learned counsel appearing on behalf of Mr. M. Soika, learned counsel for the respondent. It is submitted at bar that there is no possibility of reaching a amicable settlement between the parties, and therefore this matter may be decided on merit. Stop accordingly. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 58.
We have filed affidavit regarding paper publication and copy of the newspaper is.
Yes.
The copy of the newspaper. That could be make a part for record.
Now you have to submit it.
In affidavit, we have annexed it, not in-
You have annexed it.
annexed it.
Then why are you giving it again? And Mr. U. Datta, learned counsel for the appellants, was also at Mr. S.P. Sharma, learned counsel for respondent number 2. Learned counsel for the appellant submits that the appellant has filed an affidavit regarding publication of the notice in the newspaper, notice to respondent number 1 in the newspaper, as was directed by this court. What was the date of appearance?
Today,
After considering the contents of the affidavit, the notice issued to respondent number 1 by substituted mode is held to be duly served on him. Only two respondents are there. Accordingly, the the service of notice on parties is complete. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 59. There is an order of payment.
Short break. Yes.
There is an order of payment of your retail account, but I am unable to pay you. And perhaps the first order by which the due was stayed, these are conditional orders. That within 3 months, if I will not pay, then it will be. So it is open to him for expression, let it be fixed for a date. Let the appeal be fixed for hearing, final hearing.
Third, Mr. N. Jha, learned counsel for the appellant. Also, Mr. J. Chopra, learned counsel for the respondent. Learned counsel for the appellant submits that by which order stay was granted?
Stay was not, there is no pray for. Sorry.
No stay is there.
It may fix for.
Mm,
Sorry.
Hmm.
Another case.
To continue. On perusal of the record, it appears that this matter is ready for hearing. Accordingly, list the same for hearing. Record would be necessary.
According to me, it is not.
Record is necessary.
What happened in trial court?
Trial court, the suit was decreed in favor of the plaintiff.
You have filed any execution case?
Yes,
It is pending.
actually, among the parties, there are 10 suits. Against,
So you,
I don't remember the execution case, whether in this was filed or not.
Series of case has been filed, your lordship.
Then, because both were relatives and friends, both the families.
So the cases and so the, all these executions.
Out of
10 cases, it
after the
appears
case
that
been decreed.
you are very good friends.
Two good friends.
And almost your lordship's a degree of 5 to 6 crores already passed by the.
Against you.
That is why it doesn't fair for execution. I cannot, no property.
Let this matter be listed for hearing after 4 weeks on a date to be fixed. No. Last line continue. It appears that the records of the trial court have not yet been received. The registry to issue a reminder for the same, and after receipt of the records, this matter may be listed for hearing. List this matter after 4 weeks.
Ask for the any security, the direction may be given.
No, therefore I was asking, when there is no stay, there is no stay. You may go for execution.
He doesn't go. They have taken the steps upon respond number 2 and 3 losses service is complete. And TCI also will receive. So matter may kindly be fixed for hearing.
May I please? Lordship, there is an IA today has been listed
for
withdrawal of 50% deposited amount, which has been deposited by the insurance company since 22/4/2024, your lordship.
what is the ground?
Uh,
In the appeal, what ground you have taken?
Regarding license, your learner license have possessed by the.
Huh?
Pay and recover is there. Pay and recover option is a main ground option. So the matter may go for final hearing as the TCR also been received. And they can go for 100%.
No. Pay and recovery order is there. Pay and recovery. On what appeals?
The relating to driving license.
Driving, what violation is there?
Driver was driving LMV NP. And he was having a license of LMV NP and motorcycle, whereas he was flying a commercial vehicle. So the learned member came to finding that there was violation of policy condition and directed the company to pay the compensation and later recover it from the one. So that is our main goal. So 50% at this stage, because when the matter is ready for hearing, also fix a date.
Okay, we'll fix it.
The service is completed.
As I remember, your lordship, as per this judgment of Honorable Supreme Court, lordship, 700 something, the person has been drive a commercial vehicle also, that may perhaps 775, I think, kilogram weight vehicle also drive by the owner also, driver also.
No, we'll fix a short date.
It's not fixes for it.
Heard Mr. S.P. Sharma, Learned Counsel for the appellant. Also heard Mr. S. Ayakan, Learned Counsel for respondent number 1. Office note dated 21/5/2023. 26 shows that notices issued to respondent number 2 and 3 have been duly served. The service of notice on all the parties are therefore complete. The records of the concerned MSC case have also been received. Hence, let this matter be listed for hearing. No, short date.
Lordship consider their IA during the hearing time.
Therefore, I am granting a short.
July,
16 July.
Item 61.
Lordship, as per office note dated 19/5/2026, Lordship, service for all the respondents is completed. And TCR is also received.
But Mr. A. Kakuti, Learned Counsel for the appellant, on perusal of office note dated 19/5/2026, it appears that the service of notice on all the respondents is complete and the records of MSC case, relevant MSC case has also been received. Hence, let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 62. Sorry. We have to do it.
In fact, I feel lots of this is right for a final hearing, subject to their appeal,
The complaint that can be listed for.
It is fixed for hearing.
I have filed my affidavit in objection clause. Now, subject to, if he wants to file a rejoinder, that's perfectly
No,
okay.
nothing more.
Or-
The records are already there, the TCR has already.
I heard Mr. A. Vishwas, Learned Counsel for the appellant. Also heard Mr. A. Das, Learned Counsel for respondents. It appears that
My
this,
last name is Ajoy Roy,
Yeah, Roy.
Yeah,
sorry. Heard Mr.
Ajoy Roy.
A. Roy, Learned Counsel for the respondent number.
Don't do this one.
Okay, your name is not reflected in the.
Worship, in my case also, it's, my name is not reflected there.
Learned A. Roy, Learned Counsel for the counsel for the respondent. It appears that name of Mr. A. Vishwas and Mr. A. Roy have not been reflected in the cause list. The registry is directed to reflect the name of Mr. A. Bishwas as engaged counsel for the appellant as well as Mr. A. Roy as engaged counsel for the respondents in the cause list. Let this matter be listed for hearing when
Whenever it's convenient to my learned friend.
So as he'll be coming from side. So.
You
the
choose a
first of
date.
August, your
4th of August because that's.
Sixth of August.
let this matter be listed on 6th of August.
Grateful.
Highly obliged.
Item 64. I think service may be awaited. We have taken steps of 21 minutes.
Mr. S. P. Sharma, learned counsel for the appellant. Await service report in respect of notices issued to respondents. Let this matter be listed again on 22nd July.
Item 65.
None has appeared for appellants on call. It appears from the office note dated 21/5/2026 that the service report in respect of notices issued to the respondents is awaited. It also appears that the trial court records have not yet been received. Await further for the service report. Registry to issue reminder for trial court records. Let this matter be listed 17th of July.
Hearing item 52.
Yes, Mr. Saikya.
But the insurance companies are present, but
The claimant
claimant is
respondent
not
is-
present now.
Oh. Who has filed the case?
We have filed the case lordship.
Otherwise, claimant was appearing.
Yes.
Who is appearing for claimant? Mr. Datta.
Sir S. Ahmed. Shahjahan Ahmed.
What you propose? What is the case?
The involvement of two vehicles, sir.
You are both the insurance.
Yes.
What was directed?
50-50 law.
50-50 directed.
50-50 direct.
We were given a right to recover from the owner as there is no permit. But our plea is that the search sheet was filed against the other vehicle. So we are not liable at all. And
That is their
our-
case lordship,
Yes.
but otherwise.
Other council also the pay and recovery is given, but there is no order for any security regarding that amount. And otherwise amount also is on the higher side to some extent, also 90,000 something around.
Total award is 3 lakh something lordship, 50-50 is given lordship.
Election.
We have already satisfied our 50%.
We have deposited 50% of our liability in this offer.
So your appeal will be objected to by Ms. Chaudhary also.
If there is,
But the presence of claimant would,
yes, it is not. Should be there.
we are giving a short, otherwise on last date whether claimant appeared or not.
Payment appeared in a IA.
Oh,
520.
okay. Heard Mr. A.J. Soikia, learned counsel for the appellant. Also Miss M. Chaudhary, learned counsel for respondent number 7. However, none has appeared for the claimant respondent. It appears from record that the engaged counsel for the claimant was otherwise appearing regularly before this court when the matter was called on for hearing. Considering the absence of learned counsel for the claimant, this court intends to give one more chance to the claimants before proceeding with the hearing. Accordingly, the matter is adjourned for the day. Let this matter be listed after 4 weeks on a fixed date, July. Let this matter be listed on 16th of July.
Okay. No problem.